Honorable, the Justices of the Appeals Court, now sitting in Boston, far and within the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. Please be seated.
Good morning. All right, good morning, everyone, and welcome to today's sitting of the Appeals Court. I'll introduce the panel first. To my right is Justice Suk-Young Shin. To my left is Justice Robert Toone, and my name is Ariane Vuono. We have a full list today of 6 cases. We plan on taking our break at the 4th case unless something changes, but that's our plan, and it'll be about a 15-minute break, so you can plan accordingly. I don't think I need to remind anybody here because I see a lot of people who I've seen before, but I will remind you anyway that you have 15 minutes to present your argument and there is no rebuttal in the appeals court. I always like to assure everybody that we've read everything that you've provided to us. We know the case well. 15 minutes can go by quickly, so I recommend that you get right to your most important points, all right? All that said, the first case is Commonwealth versus EUGENIO LARA, 2023-0107. Counselor?
Thank you, Your Honors. My name is Murad Arakan. I represent Mr. Lara. May it please the Court. Looking at this case, I think that there's something that is, I would say, remarkable in the sense that this case involves some circumstances which are probably some of the most significant threats to due process and fundamental fairness that one can imagine in the criminal process. And that involves a judge who was willing to secretly rely upon and accept wholesale the statements made by a core adversarial party.
Let me interrupt you for a second. My understanding is that the Commonwealth concedes that we should not look at the facts that were contained in the police report that were not testified to, correct?
Yeah, that's correct, yes.
Okay, so there's an agreement there. So I guess the issue really is whether or not the other facts are sufficient to have ruled in the way that the judge ruled.
No, Your Honor. I think that...
And of course, there was no motion to determine whether or not the judge looked at it or how he looked at it, so we don't really know if it was secret or not secret. It could have been inadvertent, et cetera, right? But there's no question that it shouldn't have happened, and the Commonwealth has commendably recognized that.
Sure. I don't think that there was any room to seriously dispute the fact that Judge Sullivan, read the police report. And I also think that it is not in the realm of speculation to determine that this was in fact secret. There's no evidence in the record that he consulted with anybody or requested permission, like in the Hilaire case, to review ex parte or to review the police report. So it is secret. It is something that happened without anybody's knowledge or permission. The point that the Commonwealth and I disagree on is what do we do about it?
Okay. What do you think we should do about it? I think I know what you think we should do. Right.
Right. The whole thing is tainted. The whole motion to suppress hearing is tainted by a judge who's willing to.
Well, what if you go before the judge and you have a hearing and you find out that the judge says, "Oh my gosh, the police report was right there. I thought it was introduced as an exhibit. It was inadvertent. I'm going to revise my rulings."
Right.
That didn't happen.
Because it's so beyond the pale. It's so beyond the pale that there is no.
Well, whose burden would it have been to do that if they were arguing this, yours or the Commonwealth's?
So, if it was a disputed fact, I suppose that it would be on the defendant to establish this. So just sort of off the cuff, I'm going to agree that would probably be, who would need to establish it. But I think that there are things that are so clear that nobody's disputing it. I mean, it happened.
Well, you did a very nice job of comparing the testimony and the report. Thank
you so much, Judge.
And in fact, persuade the Commonwealth. So I think that we can. I would like to focus on what you think the best remedy is and why that's appropriate.
So it's a structural error, Your Honor. That's the issue here, is that once an error reaches this level, you can't look at it and say, let's neatly take it out. In the same way that if you put a bad piece of meat into a soup, you can't just pluck that piece of meat out and serve it up for dinner. I mean, it's...
I don't want to belabor the point, but it often happens that a motion judge will make findings of fact, and there'll be later on a challenge to say those facts are clearly erroneous. And what we do is we excise those facts. We excise all the clearly erroneous facts, and then we move on.
Right.
And I see your point as you're saying, in this case, you don't want us to do that because you think it's so severe that
Yes.
we need to make a statement.
In the
We hear
same
you.
exact way that, like.
But you have other big issues in this case, so I don't want to.
Sure, sure. But in the same exact way that maybe we don't have a hearing at all, we just have the judge secretly meet with the police officers and tell me what the
All right,
result is.
I really think that you need to have some facts to make those kinds of allegations, but
No,
that's
no.
okay. You have other important issues in the case
Sure.
that you can
Sure.
address.
I'm
And
just
maybe
making-
even more meritorious.
Sure, sure, sure. I was just making an analogy that it's similar to that level of problematicness. So, yes, there are other problems in this case, and you know, although those issues, I think, arise only if the court is willing to engage in the excision process that the Commonwealth is recommending here, which I asked the court not to do. You know, and let me say this: even if the court were to, you know, pluck out facts, you know, and remove them from the judge's analysis, if you do that, you still have to remove the sequence of events from the analysis, because there was no evidence as to when the truck was stopped versus when the defendant was stopped. That's contained in the police report in terms of the chronology. So,
Right, all we have is the officer who testified about stopping the truck, the information of what the person, the operator of the truck said.
Correct.
Giving over the heroin, identifying, for purposes of this discussion.
Yes.
Identifying your client.
Correct.
Okay, all right. And then just says that the information was relayed.
correct.
Right, and says that to the officer who was somewhere out there.
Correct.
That's what we have.
That's right.
Right.
And so,
Had that officer had your client already in custody, do you think that would have been relayed back? Or would you say to me, which you should, that's just speculation, we don't have that? Or how do you approach that sequence right there?
right, so it's a different scenario now because we're talking about the Commonwealth having the burden of proving that this warrantless search was good.
Right.
So the Commonwealth needed to create a record to show when these things in fact happened, other than the speculation that
Or was it challenged?
I'm sorry?
Was it challenged at the motion hearing?
Yes, so I think that by arguing that there was an illegal warrantless search and seizure, that is challenging it. And it's
That was
then up to
enough.
the Commonwealth to justify it. So it's a very simple, straightforward case. The Commonwealth is, the defense is saying, prove that this is good. And that's what the defendant needed to do, and that raises the issue. So
Well, just to dig in, the Commonwealth argues that there was a basis in the record, the proper record, the excise record, from which Judge Sullivan could find that the stop of the motor vehicle occurred before the stop of your client.
Right.
What's your response?
all speculation. That's just it's all speculation. So the Commonwealth's theory is, you know, the appellate lawyer unfortunately had to try to, and she did it well, try to cobble together different facts and create a hypothesis that it is probable that the truck stop occurred first. But there's just no evidence to support it. So the
So
theory,
your position, it's not probable, is that what you said?
I'm saying, my position is that you can't come to that conclusion without speculation. It's impossible without speculation, because the Commonwealth's theory is based on, well, the location of the actual stops plus the mode of transportation means that we can assume that the stop of the truck happened first. But that's the problem, is it requires.
Also that the officer who stopped your client waited for the car to move out of sight before he started pursuing your client.
Right,
So,
but there's no testimony as to where the car went other than where it landed. So,
well, I thought it went just like 3 blocks or something, right?
well, there was no testimony as to the route that it took. The actual location of the stop, as I understand it, Your Honor, was that Kirk Street was the location of the actual stop, Kirk and Broadway, which was 3 blocks away from where the defendant was let out. But the testimony was they followed the truck and it eventually stopped at Kirk and Broadway.
Can you not infer that it went the straight route to where it was stopped?
That's just pure speculation to infer that it took a straight
So
route.
let's just assume, I know you disagree, but let's just assume that the stop of the truck occurred before the stop of your client.
Yes.
And that the driver of the truck immediately stuck out his hand with the heroin in his hand.
All good, yes.
Okay, so let's just assume that
Yes.
that happened first. Do you contest that that knowledge of the driver holding out the heroin out of his window can be imputed to the second officer or the third officer who stopped your client?
Not under privet. I don't believe that I would.
Why not?
Because it's the critical facts, and that's what privet talks about. I concede the joint investigation, and I concede the continuous communication. But there's a third element, and that is that the critical facts needed to have been communicated. And the critical facts, in my view, in this point, are not that we're talking about people from New Hampshire and people from Lawrence. That's not a critical fact. The critical fact is not that it's a high crime area. The critical facts are that the fellow in the New Hampshire car had drugs, and that he said the defendant turned them over. So none of those critical facts were relayed to Ciccarelli, at least on this record, such that I don't think that the collective knowledge doctrine would apply.
So can you explain your understanding of privet to me? The critical facts, it seems to me, you're essentially arguing that the arresting officer needed to have all the information to establish probable cause. The Commonwealth says, well, it had a lot of the information. It had the New Hampshire plates, it had the short car ride, it had the driver looking down.
Sure.
And maybe it didn't know about the driver handing the bag out the window, but it knew it knew enough.
Right.
Is that what privet says? Is sort of you don't need to know the full picture, you need to know just a critical amount of facts?
Right. It's the critical amount of facts. So I suspect that the answer is somewhere between what the Commonwealth says and somewhere between what I say. So right, and that's when we have these tests of critical facts, I mean, it's subject to interpretation. I just hope you interpret it my way. But the fact of the matter is, and I know you guys are familiar with my whole argument that these facts are so neutral that to describe them in any way as critical is a serious overstatement. But, I mean, I think that in privet, didn't my understanding is that the two officers who had the two pieces of information were there together at the same time searching the fellow and his backpack. So one of them was the no beard, and the other one was there was nobody else in the area, pieces of information. And so, although they didn't discuss it, they had those critical facts together at the time, and they were both present for the search. Here, the critical facts are, everything else was just speculation. The critical facts are, oh yeah, we did get some drugs. If they had that, we got some drugs, and that gets communicated to Ciccarelli, great. I feel like we would agree.
Maybe those are really decisive facts.
Right.
Critical facts might have a broader.
Sure, and I leave that, I leave that to smarter people like yourselves to determine what's critical and what's not. But
That is our job.
I'm sorry?
That will be our job, yes.
Yes, of course. But my take on it is simply that I think it's closer to my position than the government's position, I guess is my point. I mean, otherwise, I mean, the government's position is really kind of like, if the police have any fact, then that fact becomes a critical fact. And my position is...
Now, I have a question for you, because
course,
privet,
please.
of course, is the law. But why the 10-year gap in this case? In other words, the motion to suppress and the hearing motion happened in, 2014, 2015?
Right.
2015.
Right.
Case was tried 10 years later.
Right. So he was deported, and his wife is in a shelter, and
I see.
pulled up some money to hire a lawyer to try to get him back here. As a result of this conviction, he was deported. So that's the reason for the gap, as I understand.
But wait, but the conviction was, I'm talking about the 10 years between the motion, I see, between that then and now, because the trial was
Between then and now,
afterwards. Okay,
yes,
all right.
because I think that the trial...
Now I understand. I
Yeah,
understand.
sort of
All
at
right.
the same time. So I do want to talk about some other issues, if I could, very briefly, again, related to the motion to suppress. And I think that this case presents a good opportunity for the appeals court to look at the issue of facts that can become proxies for impermissible considerations, in the same way that the courts, beginning with, Wright in the federal court and Torres Pagan here, have recognized that, for instance, high crime area is a loaded concept that, if applied without care, can result in people having different rights depending on where they live or what their skin color is. And I think that the New Hampshire versus Lawrence resident dichotomy that is sort of like the driving force, it appears, behind the suspicions that police claim they had in this case, is something that is problematic in the same way that high crime area, if not very carefully examined, can be problematic.
What do you do with the fact that there's testimony that this task force is there basically to target interstate drug trafficking?
So this is Lawrence Police. It's not a task force per se.
Okay, so I mean, they describe themselves as a.
Sure. I guess when I think of a task force, I think about like.
Yes, we don't have to.
Sorry, Judge.
There's enough to try and agree on here. Let's not worry about that one, okay? But I see your point.
Yeah, I mean, yes, but I mean, in the same way that I guess, I want to say this in a way without being disrespectful. There are government objectives or agencies that can be formed to address, or with an objective to address something that we look back and say, that's bad. So if the task force or if the mission of these officers is to identify people from New Hampshire, which by the way means white people, and assume that they're drug users if they come to Lawrence, and meet with a Hispanic person, a Lawrence resident, that may very well be their experience, but I think that it is extraordinarily problematic to allow them to stop on that basis, and that's precisely
I'm
what
going to
occurred
check now if the panel has additional questions for you.
Yes, please.
And of course, everything you say in your brief is not waived, as you know that.
Of course.
I do, actually.
Go ahead, please.
And because you don't have a rebuttal, I just want to,
Yeah.
this case is like a painful Fourth Amendment exam on
sure.
different issues. So I just want to get you to respond quickly to, I think, two theories that the Commonwealth has, alternative theories. One is that there was enough information for the lieutenant to have reasonable suspicion to stop your client, and then when he put his hand in his pocket, that reasonable suspicion became probable cause.
Right.
Quickly, what is your response to that?
Shall I assume that there's reasonable suspicion and address the...
Assume reasonable suspicion.
Yes, then I will. So it really it rises and falls on the Wooden case, and I think that this case is distinguishable from Wooden. In Wooden, there was, two fellas that are, standing around, and one of them's got an envelope, and he's handing it to the other fella, and when the police walk up, the C's are splitting. The fellow with the envelope is tossing the envelope on the ground. The other fella has got his hand clenched and he's shoving it in his pocket. There's a lot more there beyond the simple putting the hand in the pocket than there is in our case.
More furtive movement, suspicious conduct.
The clenched fist, the separating, the suspicious separation in the sense of, responsive to the police. We don't have anything like that here.
And the second or third alternative theory is that even assuming that there wasn't probable cause to stop your client in the way they did, there would have been inevitable discovery because they would have eventually at some point learned about the driver and his drugs, and that would have been enough to then have probable cause. So therefore, under the inevitable discovery doctrine, this can be upheld.
Sure. Inevitable discovery is always Custer's last stand for a prosecutor, Judge Toone. So, I think that case law is clear that it's a demanding test, inevitable discovery, because we're conceding that people's rights have been violated here. But inevitable discovery involves certainty as a practical matter that things are going to unfold in a certain way, and it prohibits consideration of circumstances that are going to occur at some later time, as occurred, as is at issue here. So the facts are not sort of like gelled in place at the time of the seizure of the truck. So, if police had waited for the truck, stopped before they stopped and searched, my client, I mean, how much time would that have been? And what would the defendant have maybe walked into a place, maybe his own house? I mean, we don't know. There's just so many different things that could have happened in that span of time that it involves some level of, guesswork. I think one of the cases talks about, well, if the timing were different, maybe the defendant wouldn't have consented to a search of his home, I think is one of the cases.
Right, but in this case, one of the officers was actually assigned to trailing, if you will, or following your client.
Correct.
So how much more certain can you get than that?
We don't know that he would have, you just don't know what's going to happen during the trail. I mean, that's the problem. I mean, the best laid plans, I guess there's a saying about that.
That's why we talk about inevitable, right? I mean, but I see your point.
Right. We are talking about inevitable. We are talking about certainty.
Yeah.
So,
Well, thank you. Thank you.
thank you. Thank you.
Additional follow-up? No. Thank you very much for your argument.
Of
We
course,
appreciate
Judge.
it.
Thank you so much. It's my pleasure.
Good morning, may it please the court, Catherine Jansen on behalf of the Commonwealth. I guess I'll first start with the issue of the judge apparently referencing the police report for what I would suggest are some discrete facts to flesh out the narrative. And while I think that was improper, and this court under Hilaire should excise those facts that were really only contained in the police report, that I would have to concede that. And I would just suggest in Hilaire that is the appropriate mechanism. In there, I would suggest there was an even greater concern about impartiality because there, the judge found demographic facts which were necessary to help Commonwealth meet its burden that the stop was appropriate, whereas here, none of those facts were necessary, and they were generally testified to.
Just those motor vehicle infractions, you just sort of barely have testimony about that, don't you?
We do, but there was testimony that there were motor vehicle infractions, and I believe the general the testimony.
Well, we didn't know about the truck being unregistered, right? That would be excised.
That would be excised, yes. But I believe
You're down to the brake light.
it was like it was general testimony about, I believe one of the brake lights was not working and there was no turn signal. It didn't say it was the right brake light and they didn't use the left turn signal. So there was testimony sufficient to say there were civil infractions which would have justified the stop. And I would suggest that there was and I would also suggest the police report does not state that the motor vehicle stop happened before the stop of the defendant. It says, kind of talks about it being contemporaneous or like at the same time. So I don't think the judge, could be fairly characterized, the judge implicitly found that the motor vehicle stop happened before the stop of the defendant because he apparently looked at the police report. But that being said, I do think it's implicit in his findings, and there's a basis in the record to find that the motor vehicle stop did happen before. And I guess I would note this before getting to that point. It seems like it wasn't really challenged by the defense attorney below about the timing of the motor vehicle stop. The prosecutor was going to call Lieutenant Chiarelli, I might be mispronouncing his name, but and the defense attorney was like basically essentially said, well, I think if we get to the motor vehicle stop and if it's okay, then we don't really need to go any further, and so not so many words. I'm paraphrasing, and the judge said, I'd like to hear some more. So to that extent about the timing of everything,
But you would agree, your brother makes a correct point.
It is, and I was just about to say,
burden.
it is the Commonwealth's burden. So once, the defense, the hearing moved forward, the Commonwealth should have maybe made it a little bit cleaner and elicited that, but I do think that there is a basis in the record in the fact that there was a plan to follow the...
So you would say there's a basis in the record for the judge's finding. At the same time, Lieutenant, I'll say Chiarelli, because I'm not sure either how it's pronounced, followed the defendant as he walked away from the scene, and that finding is supported by the evidence. And from that finding, one can then infer collective knowledge imputed from the officers who stopped the truck to this one, without any more said about it than that.
Well, I think that it's not just imputed knowledge. I think you do have to get to the stop of the motor vehicle being before the stop of the defendant.
Okay.
I do think that's important.
When I say imputed, I mean conveyed. That's a better word.
Yes. So
It just, the stop has to be first, or the statements also have to be first?
I think the important event is the stop of the truck and the hand going immediately out with the heroin that was
Later
immediately
statement was
recognized.
after Miranda was
After
given.
Miranda,
So we
and-
can't, certainly can't infer that happened before the stop of the defendant, right?
I think it would be a closer call in terms of, there is no testimony about how fast the defendant was walking and how long it took.
Or you could have a very slow talker.
Or very,
Right? I mean, there's no way we can infer
right.
which
And
one
so,
happened
I mean, I do think the fact that he waited to get out of his car until the truck was out of sight, which is, it's only 3 blocks, and verbally, that's when he turned right onto Kirk Street, and all this began to unfold. I mean, I think it would be a closer call on that inference, but I do think, if, for argument's sake, that you don't get the statement, hey, it was that guy who got out of my car. I think the handout with the heroin would be enough, because that would be akin to other probable cause cases where you see an exchange of contraband or cash currency that would give it, make it rise to probable cause. So I do think that would be enough, and that would be the important moment that you would, and then I think that would be more than a fair inference based on the testimony and how it came out.
So you also would say then that you think it's fair to infer that as soon as that happened, since they were, your argument would be that they were in close communication and that would have been relayed immediately
Yes.
without actually anyone saying that. That's an inference of it that you think is a reasonable
Well, I
inference?
think it's an inference because the testimony was after, they gave Miranda, he got the statements about the defendant, they relayed that to the officer. So I think they're relaying the results of the motor vehicle stop. So I think their knowledge of the heroin is, even without it being relayed to the officer that's stopping the defendant, is imputed to them. It doesn't need to be, the fact that it got relayed maybe a minute or two later after Miranda and those statements are made is not dispositive under Privet. And the stopping officer did have a lot of critical information about probable cause, and they don't need to have all the information, if otherwise there's no point of collective knowledge doctrine.
Okay, so hopefully you can explain your view of Privet to me. What is the critical information that the arresting officer needs to have? How much?
So I'm probably not going to like this answer, but I think it depends on the case. And in this case, I think he had almost all of the facts up. The fact that there were drugs that came out. So the fact that it's a New Hampshire plate, that he's waiting around for somebody. He's looking down at his lap. He sees the truck, the defendant get into a truck. They go drive around the block 30 seconds for 4 blocks. The defendant gets out. The truck goes off in the same direction from which the defendant had originally been walking, and the defendant walks back in the same direction as that truck is moving, and doesn't go into a store. It's not like he's getting a ride someplace and going into a store, which would presumably be located, Broadway's a busy street. And so I think those are important facts that I argue in my brief that those give rise to reasonable suspicion. And so you have that little extra fact to get to probable cause. And I mean, I think that's the point of collective knowledge, is you take it, if you have almost all the information or most of the information, you're missing that one little piece, that's okay. It's a very roundabout answer. I apologize.
I mean, is it enough, though, for even reasonable suspicion, just those facts alone? I mean, someone getting a ride in a city itself seems pretty anodyne. The driver looking down, that happens a lot. and the directions they go in, it just seems a little thin.
Well, I mean, I would suggest that each fact on their own definitely would not be enough. But when you're looking at this in the totality of the circumstances, which you must for reasonable suspicion, and through the lens of these very experienced narcotics officers, with the fact that it's an out-of-state plate, and then you have things that they've seen the script time and time again in this specific neighborhood where they are, for this very reason, surveilling. And so when you have take the totality of the out-of-state plate, which is significant, the fact that he's looking down his lap, either potentially looking at a cell phone or doing drugs, but they don't know yet, obviously, but that is a fact that through their lens of experience about that they're potentially waiting to meet up with somebody. Then look, he met up with somebody. And then this is the classic ride to nowhere, 30 seconds and 4 blocks. And the fact that, maybe if he had walked into a store, it might be a different analysis, because then you could be like, well, wouldn't want to walk, a half a mile potentially, just to go to a store. But that's not, it seems like he's getting a ride to nowhere because he's getting dropped off on the side of the road, he's not going anyplace, and then he's walking back in the same direction that he had come from.
Without the information from the driver of the truck, to justify the search, the only additional fact you're relying on is that he put his hand in his pocket, right?
Yes, and I would suggest, I think the facts in Vuono are a little bit stronger, but again, it says in the totality of the circumstance, when you're doing a furtive gesture in response to the police and shoving something back into your pocket like that, that can be enough to rise it to...
Did he characterize it as furtive, the detective?
He didn't use the words furtive, but he did say he saw me and he shoved his hand back in his pocket. I mean, I think that's, his response was, I think it was clear from his testimony, his impression was that he was trying to hide whatever he had in his hand from the police officer upon seeing him. The police officer ran up behind him and said, "Stop, Lawrence, police," and he goes like this. So,
I guess you could. I hadn't thought about it that way at all, actually. I just thought he was putting his hand in his pocket, but...
And I believe, I have to go back and look at the transcript, but I believe when you...
I read the transcript, and I just didn't, but we'll review it again.
I think it's a transcript page 23. The pertinent testimony is that it was in response to seeing the police officer.
Okay, we'll double check that.
If he had just stood there and didn't move his hands, you wouldn't get into the pocket
I think we would not get into the pocket,
until
correct.
the information is communicated from the officers who stopped the truck.
Correct.
And that's why you're arguing inevitable discovery.
As an alternative, should the court not agree with my argument on reasonable suspicion, and then things develop?
No, I mean, so let's say that the stop was justified by reasonable suspicion. Is your argument on inevitable discovery concerning the stop or the search? Or both?
It's both.
Okay.
I think that's how I briefed it, and I think that would be my position, that even if the court doesn't find there's enough to stop at all, I still think they had a plan that one officer was going to follow the defendant and the other officers were going to follow the truck, and that this stop was going to happen, and there's testimony they were in continuous communication, and so he was going to be following him no matter what. And I mean, this is akin to inevitable discovery cases where, I don't know if it's Greenwood. I'm sorry, I apologize, can't remember the case. But one was, there would have been inevitable discovery because the victim would have done the show-up identification, and that would have been inevitable discovery. And so, the victim might, in that case, the victim might not have, identified the defendant, but there they did, and then that would have been relayed. And so, I think here the fact that they had this plan, they were going to do this plan no matter what. I mean, it was just, he jumped the gun. And as Justice Wetland said in Privet in her concurrence, oftentimes if one officer acts too swiftly and just doesn't wait for that little piece of information, it's inevitable discovery.
So talk me through this. So let's just assume the stop was fine. But that the putting the hand in the pocket isn't enough for probable cause. You're saying it's inevitable discovery because once the other officers who stopped the truck communicate the information they learned from the driver, that it's virtually certain that the defendant would have been arrested and then searched incident to arrest? Is that your argument?
Correct. I mean,
do you have a case, the best case you can cite on that? No?
I don't.
Okay.
I just cited cases on the general principle of inevitable discovery. I did look.
How can we assess your inevitable discovery argument without factual findings from the judge? I know that it was raised, but he didn't rule on it even in the alternative, so.
Well, perhaps if the court feels like it can't, a remand for an assessment on that would be appropriate. I mean, this is a whole case, but I think, and I can't remember if, honestly, from the rest of the other cases I cite, if the
We
judge
have
made
done that in the
findings.
past upon occasion when, because at least it was raised by the Commonwealth, but Justice Toone makes a good point. There was no facts that were established, but this case is quite old. I mean, this happened a long time ago. So is that really a viable option?
It could be. The judge keeps, I'm not a judge, but the judge might keep notes and have in memory of this upon looking back at the case.
What additional facts would be relevant as to whether the search would have been inevitable? The officers subjective belief, they would have arrested him and searched him? I mean, what additional facts would we ask for?
Well, I mean, I guess it was more factual findings from the judge, but I don't think we could have another hearing on it and ask the officer
Well, I'm just
to elaborate,
asking,
but-
like, are there additional facts that would?
I
be
mean, I
added?
don't think so. I think it was clear from the record that they were going to keep targets. They had 2 targets, and they were going to follow them, and they were going to stop them eventually. And so I think he wasn't going to let this defendant out of his sight. So if he had just waited.
That's the point, testimony along those lines, right? That was actually the plan, that Ceccarelli was not going to let your client, the defendant, out of his sight. And maybe, of course, some information about the actual sequence of, instead of saying, the judge here says at the same time that the truck stopped and the defendant was stopped. I would imagine if the Commonwealth was really, if it was their primary theory, inevitable discovery, that information would have been presented to the evidence along those lines would have been presented to the motion judge.
Correct, and of course, our theory was
Yeah.
they have probable cause and reasonable suspicion. I'm happy to answer any other questions the
I
court
just
may
want to
have.
make sure that I understand your argument under Privet, that are you saying under the collective knowledge doctrine that Officer or Detective Ceccarelli the information had to have been conveyed to him about the arm going out and the confirmation that, or what appeared to be, that the operator had drugs, needed to actually have that conveyed to him before he stopped? You're not saying that, are you?
No,
Okay.
that's
Just-
imputed,
I thought I
because
heard you
that's
say
the
that.
purpose. Maybe I misspoke, and I
No,
apologize.
I could have misheard you, so I just
Yeah.
wanted to be sure.
Yeah,
All
no,
right.
because otherwise, I feel like I wouldn't be arguing collective knowledge. That would just be a fact you would
all right.
have.
All right, let me see if the panel has any further questions. No? Thank you. No. Thank you both
Thank you
very
very
much.
much.
Okay. Our next case is Commonwealth versus Diane Gilligan, 2023-0617. Good
May it
morning.
please the court, my name is Christine Wetzel, and I represent Diane Gilligan. In this case, we are asking that this court set aside this felony verdict for 3 reasons. The first is that the verdict on this felony charge is not reasonably supported by the evidence. And my argument here is going to embellish upon my argument in my brief. My argument in my brief was simply that there was no evidence to support malice. In reviewing the Commonwealth's brief, I more clearly understood their position, and they're suggesting that malice can be inferred by the deliberate act of Ms. Gilligan. The Commonwealth failed to present direct evidence to support the required element of malice, and we know from the case Commonwealth versus Morris cited by the Commonwealth that makes clear there must be direct evidence of malice to support the inference. The Commonwealth argues the deliberate and swift nature by which the defendant shattered the car window suggests hostility or cruelty, but to act with malice, one must act not only deliberately, but out of cruelty, hostility, or revenge. The Commonwealth further argues that we can draw the inference from the deliberate act that there could be no other reason that the defendant acted than to be cruel to her neighbor. However, Ms. Gilligan's testimony tells us there can be another reason. Ms. Gilligan admitted that she deliberately hit the window, but she did it to prevent what she saw, blowing glass, from falling onto the pavement.
Why isn't that refuted by the video evidence?
I'm sorry, by what?
Why isn't the alternative explanation refuted by the video evidence that shows her walking directly up to the window, hitting it, and walking directly away, or immediately away?
Well, she did act quickly. She walked up to the window. Her testimony was that she saw some damage to the window, hit it. After she left, she went to report, attempted to report the damage to the police, came back, covered the window to protect the car from it.
Right, but the jury didn't have to believe that she actually saw it, and the video arguably does not support that.
But to find malice, there would have been had to have been some direct evidence beyond the deliberate act of hitting the window for the jury to find a determination of malice that could be supported. And we're saying there was no direct evidence. So, for example, if she walked up to the window and she yelled a bunch of expletives and said, out loud to her neighbor, "I'll show you, this'll show you," that would have been an example of direct evidence that could support their inference that she did it that she did it with hostility or cruelty.
I mean, there was no outburst, but can't the jury infer malice from kind of the inexplicable nature of the act itself? It just seems very odd to break someone's car window purportedly because there's pre-existing damage to it without at least bringing the matter to the car owner first, right? I mean, isn't there some degree of latitude for the jury to kind of infer malice, the element of malice from just the very strange circumstances here?
I would suggest not, Your Honor. I would suggest that they would need something more direct than that. She, in her testimony, testified to the fact that she had a similar situation with her parents' automobile that had a Boeing that nothing was done and the glass ultimately broke out onto the pavement. So she had a previous experience where she foresaw something like this happening, and that's what caused her to act the way she did. So we're suggesting the deliberate nature of the act in and of itself without more cannot support an inference of malice. So the second reason that we ask the court to set aside this verdict is because the unpreserved erroneous jury instruction created a substantial risk of a miscarriage of justice. As you know, there were two instructions, one correct, that it had to be done willfully with malice, and the other incorrect, willfully or maliciously. There's a likelihood the jury relied upon the second erroneous instruction, and Ms. Gilligan was convicted of a willful but not a malicious act, and thus she was convicted of a state of mind less than required by the statute. This is a slip of the tongue. The judge simply made a mistake. But a slip of the tongue can result in reversible error. The question for this court is, after reviewing the record, can you say with fair assurance that the jurors relied on the correct instruction? If we cannot say with a fair assurance that the judgment was not substantially swayed by the error, it is impossible to conclude that substantial rights were not affected. Only where there is little chance that the jury would have misunderstood the correct import of the charge can the verdict stand.
So if neither of the attorneys nor the judge noticed the slip of the tongue, can't we infer the jury? Can it be inferred that the jury didn't notice it either?
It's certainly possible that the jury didn't notice, but I would say that would not rise to the level of the assurance that the court should find in feeling that there was little to no way for the jury to have.
Well, it's easy to miss an and the attorneys and the judge missed it, but the correct instruction that the Commonwealth had to prove willfulness with malice, that seems to me to leave very little room for doubt that a finding of malice is required. The phrasing of the correct instruction seems to me to be more definitive than the incorrect instruction.
I agree, but we can't say, Your Honor, with certainty or with any assurance that the jury heard that instruction and did not hear the second.
Anytime there's a slip of a tongue, that leads to reversal. Any time the judge makes a slip of tongue, that requires reversal?
I have to say I have not found a case where that's happened. However, if I may, the judge in his trial memorandum cited several cases where the court did not reverse on slip of the tongue, and they're all distinguishable from here. So Commonwealth versus Owens, in that case, the judge interchanged the words purposely and intentionally, and the court found there was no significant difference between those terms. Here, there's clearly a significant difference between the words with and or. In Commonwealth versus Rodriguez, there were two conflicting charges, but the judge gave the correct charges in written instructions to the jury for deliberations. That didn't happen here. In the last one, Commonwealth versus Kuntz, the judge gave repeated correct instructions. Here, there was only one correct instruction and one incorrect instruction. The appellate cases are clear. We could only let a conviction following an erroneous jury instruction even a slip of the tongue, stand where it could not have misled or been misunderstood by a reasonable juror. It is easy to see how the incorrect instruction here could have misled the jury to find guilt without finding malice. The Commonwealth also argues in its brief that somehow the slip of the tongue was remedied by the original charging instruction given by the clerk and by defense counsel's closing argument. But both of those are irrelevant to this point because, as in all trials, the judge in this case instructed the jury, it is your duty as jurors to accept the law as I stated to you. You must follow the law as I give it to you. Not as a clerk may have stated it in the charging instruction, or not as a defense counsel may have stated it in his closing argument. The third reason we ask that you set aside the verdict is because the allowance of testimony regarding video evidence, which was not preserved and produced, and which defendant had no opportunity to review, prejudiced the defendant and deprived her of constitutional rights. In response to the defendant's motion in limine regarding the video, the court had limited testimony, so all of the parties were only supposed to testify to the video of March 8th, not to any video prior to that. However, during redirect, the Commonwealth elicited testimony from Ms. O'Brien, which stated, I watched every minute of the entire period, meaning March 6th, March 7th, and March 8th, and there was nothing else that showed anything that have caused the jury the window to break. The trial judge ruled that defense counsel had opened the door to that. The trial judge stated, defense counsel elicited testimony regarding video from prior to March 8th by questioning Ms. O'Brien about the state of her knowledge of what occurred to her vehicle while she was away on her trip. However, we suggest the trial judge has misinterpreted defense counsel's question. Defense counsel asked Ms. O'Brien only about her knowledge prior to seeing the video. Specifically, defense counsel asked, you have no idea what may or may not have happened to that window prior to seeing the video and coming home. He wasn't asking a broad question about
Those weren't the only questions. I mean, there was a significant portion of the cross that was devoted to eliciting the point that there was only one video that the jury saw from March 8th.
Yes.
That we don't know what happened between the time that she left for her trip and came back and watched that video, and that she has no personal knowledge because she wasn't there, because she was on her trip. Why isn't that enough to open the door? Isn't that exploiting the exclusion of the video evidence during that time frame?
I didn't read the testimony in the same way. My understanding was that the judge's interpretation of counsel opening the door was, and I think it's in his memorandum, was this language that specifically, where the defense counsel specifically questioned about her knowledge prior to seeing the video.
All right. Well, what's our standard of review? Do you agree it's abuse of discretion?
I think that this court can look at the transcript and look at both the cross-examination and the redirect examination to make its interpretation of whether defense counsel had opened the door.
But it's an abuse of discretion standard, right?
Although a judge in a motion for a new trial, while they generally have broad discretion in deciding that, they do not have discretion where the original proceeding is infected with prejudice and constitutional error. And I would say that there's enough instances where we're concerned that Ms. Gilligan's constitutional rights may have been infringed, and the use of this video and the testimony related to the video is highly prejudicial.
Right.
So if there are no further questions, I'll conclude. We respectfully request that this court set aside the felony verdict because, one, Ms. Gilligan was found guilty of a felony charge without sufficient direct evidence to support a finding of malice. Two, we cannot conclude with a fair assurance that the jury relied upon the correct instruction, thus the erroneous jury instruction regarding malice resulted in a miscarriage of justice. And three, defendant was prejudiced by the admission of testimony of the unpreserved video.
All right.
Thank you for
That's
your
your
time.
conclusion, but one moment before you leave the podium, I haven't checked with the panel to see if they have any questions, and they don't. That's perfectly okay. We're all set. Thank you.
Thank you.
Good morning, and may it please the Court, Mackenzie Slyman on behalf of the Commonwealth. I'd first like to acknowledge Ross Piscatello, who assisted with the drafting of the Commonwealth's brief in this case. If I may, I'll start with the first issue raised by the defendant here, the sufficiency of the evidence in this case. Justice Toone, I think, as you stated to counsel, this is a situation where the jury can clearly infer malice from the inexplicability of this act here. The video makes very clear, the 3 clips in front of them, that the defendant comes out of her condo, walks quickly up and down the driveway, and then approaches the victim's vehicle and doesn't spend any time evaluating the window before hitting it with whatever she had in her hand. She hits it twice, at least, which is captured in videos, clips 2 and 3. You can hear that from what she does, you can hear her hitting the window, you can hear it smashing. She then gets in her vehicle, leaves, returns back, comes back to the vehicle, hits it again, hits it, by my count, I think at least 4 or 5 times, as captured in clip number 1, before she then essentially does damage control, goes inside, gets a trash bag to put over the car. And I think also most importantly here, she does all of this before even attempting to reach out to the victim about the vehicle. She
did go to try to report it to the police, though, which is unusual.
The defendant states that that's where she went. There's nothing in the record that supports that beyond her own testimony, so that's certainly up to the jury to decide whether or not what she says is accurate. But the motion for required finding first came at the close of the Commonwealth's case, and we didn't know where she went. All we know is that she left briefly and returned. I think this is a situation where it's apparent from, as you said, Justice Toone, the inexplicability of this, where there wasn't any time contemplating what's the status of, what's the state of this window. She went directly up to it and hit it. I would point to Commonwealth versus Rumkin, which I cite in my brief, which is, I think, a similar situation where in that case the defendant deliberately and repeatedly kicked another door, causing damage to the car door and I think smashing a mirror after there was a motor vehicle accident. Again, that behavior illustrating a hostile intent in doing so. Turning to the jury.
There was no testimony here about a hostile relationship between the two.
There wasn't. It's not. I believe that there was prior to impanelment conversations between the parties about.
I'm talking about in front of the jury.
Correct, about a prior relationship, but that was kept out. So there was nothing in front of the jury about any.
It was excluded, right?
Yes. Yeah. So that was not put in front of the jury. They were only.
Why was it excluded?
I believe the conversation surrounded it being viewed as a prior bad act or. Unduly prejudicial to the defendant, the nature of the relationship. I believe it is captured in the transcript. I apologize, I don't recall it off the top of my head, but it was not put in front of the jury. If the court has no further questions on that issue, I'll turn to the jury instruction. This court is evaluating, as you know, the slip of the tongue for whether it created a substantial risk of a miscarriage of justice here. I disagree with my sister as to the relevancy of the fact that willfully with malice was previewed by the clerk and the defense counsel, that has no value here. I know that counsel classifies that as irrelevant. I would disagree. The clerk in the preliminary charge, I suppose, to the jury said that the defendant was charged with vandalism by intentionally, willfully, and maliciously or wantonly causing the destruction. And defense counsel made it abundantly clear in his closing, though I recognize that closing argument is just argument, to quote directly, so the elements of the offense are that it has to be malicious. It has to be willful, intentional, and malicious. So those 2 pieces alone preview for the jury that it needs to be willful with malice. I think we'd be in a different situation if the judge's first correct instruction was that the defendant acted willfully and maliciously, and then soon after said willfully or maliciously. I think the parallel nature of those 2 statements might be a harder sell for me. But in this situation, the judge tells them very clearly that the third element that the Commonwealth has to prove is that the defendant acted willfully with malice. So the slip of the tongue that comes later, willfully or maliciously, is entirely different from how it was first classified by the judge, very clearly different language, and where it was already previewed by, in 2 prior statements, there is not a significant risk here that the jury was misunderstood. I think also relevant is the fact that the defense counsel, the ADA, nor the judge caught that slip of the tongue, which would suggest that the jury too would not have picked up on it.
How do we assess this from the ineffective assistance frame, right? Because obviously this is an understandable thing. no, everybody misses something, right? But it is the job of the defense lawyer to catch these things. And so I just don't know how we assess the first prong of the Safarian analysis, sort of, did this fall below an objective standard that's expected of defense counsel? They're supposed to listen to the instructions, particularly on the instruction that's critical to the defense here. So how do you just look at that part of the ineffective assistance analysis?
Sure. So I think it again has to be viewed as an erroneous jury instruction is in the context of the instruction in its entirety. That though the defense counsel missed this, they were dialed in and heard that the correct instruction be given first. That the defense counsel themselves knew that they were doing their best to ensure that the defendant's best defense here, that this was not a malicious act, by previewing it in his closing argument. But I think especially where we're dealing with the question of does the conduct here fall below fall measurably below what would be expected from an ordinary fallible lawyer, I think that question is answered by the fact that no one in the room picked up on this slip of the tongue.
But only one person in the room was charged with defending the defendant's rights, right? That was the defense lawyer, right? And I just, again, it's totally understandable, but I just don't know how we assess this. We want defense lawyers to be catching these things.
And I think, it might not be a direct comparison here, but I think that, we have ample situations in case law that support situations where there is an erroneous either instruction made or, a statement made in closing argument or a question asked by the Commonwealth during the presentation of the case where counsel does not object. And, certainly in those situations, it can be viewed as a strategic decision or not wanting to draw attention to that slip of, that erroneous thing that was said.
There was no strategic point here.
Yes,
right?
certainly not in this situation. But I make that point to say that I don't think that it's a black and white question of if there is an erroneous instruction that is not objected to, that automatically indicates that there's an ineffective, that was
Not automatic, that wasn't the question, whether it was automatic, but whether or not it does fall below what one would expect from a reasonably fallible lawyer.
And I would say
That's
it does
different
not
than
fall
saying
below.
that something is automatic.
Of course, Your Honor. And yes, to answer your question, I would say that this definitely does not fall measurably below where we look at the nature of this, it was a very small or turned around. Had that been repeated throughout the instructions.
I think you're saying also the standard review would still be substantial risk of a miscarriage of justice right?
For ineffective assistance, my understanding is that we're looking at an abuse of discretion.
No, but in other words, the defense attorney's at failure to object.
Yes, that's a substantial risk of a miscarriage of justice. And I outlined in my brief there are four elements four factors essentially that the court looks at for that. And I would argue that those are all, that the Commonwealth clears that bar here, illustrating that this was not a substantial risk. Turning to the last issue of the video evidence that went in, again, this court is reviewing that determination by the judge for an abuse of discretion and gives special deference, whereas here the motion judge on the defendant's motion for new trial was the trial judge in this case. Again, I disagree with counsel that defense counsel did not open the door to this line of questioning in his cross-examination. And I think and I'm looking at, and I believe as Justice Shin pointed out, this isn't one isolated question that opened the door. I think the cross in its, in a large portion of it opens this door. But in particular, on page 85 of the transcript, the counsel asked Ms. O'Brien, you have no idea what may or may not have happened to that window prior to you seeing the video and coming home, correct? I think that, if anything, opens the door here because, as was pointed out, counsel strategically, knowing the motion eliminating decision that they received, really focused on illustrating to the jury at that time that there was only the video clips that they had in front of them that were reviewed here. So by referencing you didn't see anything prior to seeing the video, I think the trial judge correctly saw that as suggesting improperly to the jury that this is the only video that you reviewed in this case, which certainly leaves the Commonwealth in a prejudiced position of now the jury has has been left with the wrong impression that Ms. O'Brien had no idea what had happened to her car up until watching these isolated clips of the defendant's actions towards it. So it certainly, obviously the Commonwealth's position is that it was the correct decision, but certainly does not fall outside the reasonable alternatives here and was not an abuse of discretion. And if the court has no further questions, I will rest on my brief.
I see no questions, so thank you both very much. We'll take the case under advisement.
Thank you.
Okay, we'll move on now to our third criminal case that's on our list, which is Commonwealth versus Dennis BAIN, 2023-0459.
Good morning, Your Honors. May it please the Court. My name is Tristan Colangelo on behalf of Defendant Dennis BAIN. This appeal includes two issues, the first being whether the conviction of Mr. Bain's 209A violation should stand and whether he violated the terms of his probation. Concerning the 209A conviction, the order can't stand because the evidence concerning the no contact order was contradictory as to whether he was permitted to contact the complainant or not. Mr. Bain moved for a required finding required finding at the end of the evidence, so this is viewed under the Lattimore standard, and essentially the argument is that the Commonwealth failed to prove an essential element of the crime. Where their evidence tends to prove two reasonable conclusions equally, then neither can be called to be proved. So here the complainant conceded that Mr. Bain was permitted to contact her by sending her checks in the mail, and that's what he did on these three occasions. Now the Commonwealth contends that the additional questions or letters that were included were what violated the order, but the order, and it was the Commonwealth's position at trial, was that no contact was allowed at all. So if the complainant is conceding that Mr.
Well, I think that the issue was is that the checks were received, and that was all right, but it was the including the letters with the checks that was problematic.
Well, right, but the Commonwealth's position was that he was not allowed to contact her at all. So thereby sending her something, anything in the mail would have violated that no contact order. That was the position that the Commonwealth took.
So what do you take from that then, that there wasn't any no contact order in effect at all? I mean, the order is very emphatic. You were ordered not to contact the plaintiff in writing electronically, and you're saying, well, he had to send checks to her. Mm-hmm. So therefore, what follows from that? I mean, go ahead.
Sorry, I was just going to say that the 209A order that they presented was not as ironclad as it was intended to be, because there were two instances in which the complainant was allowed to contact her, or at least evidence showing that he could have. One is her concession that he could send her these checks in the mail, and the second was her adoption of the temporary order from the Family and Probate Court. So the Commonwealth's case was presented as you're not allowed to contact her at all for any reason, but then the evidence from the Commonwealth's own witness suggests that he in fact was allowed to at least contact her for purposes of sending her checks in the mail and at least for purposes of dealing with the kids.
Yeah, but does that vitiate the no contact order altogether, or is it reasonable to interpret, say these orders need to be interpreted in their totality, and nevertheless what your client did crossed the line by including substantive notes within the letters that were sent with the checks?
I think Your Honor's getting to the point, is that it presents a contradiction in and of itself, and we're here now trying to suss out whether what he did violated the order or not, when that's what should have happened at trial. The Commonwealth should have proven that he was not allowed to contact her for any reason, if that was their position, or if there was contact permitted, he was allowed to only send checks and nothing else, or only send an email and nothing else. None of that was provided by the Commonwealth. I think that's their burden. Now, my understanding here is that, and you know, one way that this case is different from, you know, Rousseau, in which, you know, the court found that there was some obligation on a defendant to provide superseding orders from a probate and family court. This defendant did present evidence. There is at least some production of evidence that suggests that he was allowed to contact the complainant here. That was not the case in Rousseau, and I think that's a big, you know, significant distinction. So we do have this ability of some contact, and I don't think it's the defendant's burden to prove beyond a reasonable doubt that he was allowed to communicate in certain ways, but it's the Commonwealth's burden to prove beyond a reasonable doubt that he was not allowed to.
So is it your position then, if the Commonwealth proceeds on a theory, and arguably the evidence does not support the theory, but it does support a violation beyond a reasonable doubt, it does support a violation of the crime as it has been described, or not just described, but as the jury has been instructed by the judge, that the case cannot stand?
I don't think it's necessarily a difference of theory. I think here it's just the Commonwealth failed to prove beyond a reasonable doubt that he did commit the violation.
Well, would you agree that they proved beyond a reasonable doubt that he sent a letter?
Yes, of course.
And could the jury infer beyond a reasonable doubt that a letter is not included in the order?
Based on this evidence,
Uh-huh.
yes, I believe so.
Okay.
And I think that's the problem, is that there was, that's the concession that the complaint made, was that that was permitted, that was allowed. It was the rest of it that wasn't, and that distinction isn't in the 209A order. It's not part of.
So is your argument that the no contact provision is ambiguous?
That there were other orders, other court orders that allowed the communication.
Which made the scope of the no contact provision ambiguous?
That modified it. That modified it to allow him to communicate in certain ways.
But there's no order from the probate court that allowed him to send letters, right?
There's an order that allowed him to send emails. I'm not sure there's a material distinction between an email and regular mail, but yes. The temporary order that was adopted by the complainant during her testimony did allow that.
Well, is it reasonable to infer, could the jury infer that there's a significant difference between an email and a letter?
I would say no. I really don't think that there's much of a difference between an email and a letter. They're both forms of communication. One's just, the 2000s version of writing a letter.
The probate and family court thought there was a difference.
It did say email. I agree with that. It did not distinguish between letters or not, but I think it goes to that's one piece of it. The other piece is that she conceded on the stand that he was allowed to send her letter.
By that old-fashioned, I think that letters are different than emails? Is that?
I'm suggesting I'm that old-fashioned. But, the other piece of this was that the complainant did concede that he was allowed to send her the child support checks by mail. So I do believe by either medium, there was evidence presented that he was allowed to at least contact her either way.
Yeah, but just because you're allowed to send a check doesn't mean you can do anything else. You can put anything else in that letter, right? I mean, that's the problem.
Well, I think that was the Commonwealth's burden to show that yes, this was okay, but this was not. I mean, that's the idea of the burden of proof for the Commonwealth. They must prove beyond a reasonable doubt that what he did violated the statute or the order, whatever we're talking about. And here they presented an order that said no contact at all, and then you have contradictory evidence in two different instances in which he was allowed to.
But the contradictory evidence only goes so far as email and check. So I'm putting aside your view that email and letter are the same thing, okay? Putting that aside. Mm-hmm. If they're not the same thing, then you're saying that still the Commonwealth has not met its burden.
Yeah, I think that significantly undercuts a Commonwealth case.
Even if the letter was something far more drastic than we have here, because already here there was some information about, let me see my children and have a heart and things along those nature, right? Which she testified were quite upsetting to her. What if the letters contained even more personal information or something along those lines? Your view would be the same.
I think the Commonwealth could have moved on a different theory. Certainly, if there was more extreme or egregious content in the letters, they could have moved on a theory of, continued abuse,
But not
threats.
the no contact.
Not the no
order.
contact.
Your position is nothing that the defendant could have put into these letters would have arose to a violation of the no contact order.
Right. If he was permitted to contact her, he was permitted to contact her. Their theory was that he was not allowed to contact her at all under any circumstances. But then the evidence that came in demonstrated that he was. So that's the inherent contradiction. I just don't see how you can get around that. And as I said, there's some burden on him to provide evidence that he was allowed to contact her, and I think he did here. Regarding the testimony that the complainant provided about her emotional response, none of that should have been allowed to enter the trial in this case. And certainly there was no reason to call Officer Scola other than to provide this testimony to perhaps sway the jury to provide some protection to a woman who, as in his terms, needed help and she wasn't getting it.
Well, the Commonwealth says we had two different theories going into this proceeding, and one was no abuse and one was no contact. And only at the end did they decide just to focus on the no contact. So why aren't they allowed to develop their case as to the other theory if that was part of the case from the start.
Yeah, I don't think the record supports that. If you look at the transcript from start to finish, I don't see any instance in which the Commonwealth claims that they are pursuing a conviction based on abuse. It is entirely based on the receipt of these letters and that there was a no-contact order in place. I don't see any mention of it anywhere along the way, and certainly by the time we get to the end of the case with the charge conference, there was no objection. I believe there was no objection to just pursuing on the no-contact piece and the abuse part of it being stricken.
So if they had pursued, if there was evidence, in some indication they were pursuing a no abuse theory from the start, then would you say, well, that was allowable, even though they decided not to pursue that theory at the end?
I think I would, yeah, I think that would be correct, because at that point, then this evidence of her emotional response and the effect that it had on her would have been significant. I may still object to Officer Scholar testifying. I'm not necessarily sure that there was any reason for him to testify other than to show her emotional response, but his testimony, with a mask on, and I think that would be objectionable still, but, the rest of it I think probably would come in.
Okay.
And then, Your Honors, if I may touch briefly on the violations of the probation order. The Commonwealth has the burden of showing there that he willfully violated the terms of his probation. And here, the main piece was that he failed to enroll in the batterers program a mere 4 weeks after the order. And I don't think that's a sufficient amount of time to allow him to decide whether he's going to enter it or not, or to sufficiently prove that he would not have complied with that order, given the fact that there was no deadline or no time constraints required for him to enroll in the program by a certain date.
It would be one thing if the defendant hadn't simply just hadn't enrolled in the program and 4 weeks had gone by. But we have something different here. We have his very angry response to the director, combined with his failure to kind of take any action to try to modify the requirement. It seems to move this closer to a violation, at least under the preponderance standard. How do you respond to that?
I would agree that it moves it closer, but it doesn't quite get there yet. I mean, 4 weeks is a pretty short amount of time, and obviously, based on what you've read about my client, he can be emotional at times and take a strong position about things. It's not to say that he wouldn't eventually have complied.
How much time is he entitled to before he actually starts to comply?
It's a good question, and I think that would be somebody should set those parameters, whether it be the judge or even a probation officer, to say, look, you need to do this. This is a requirement. Enroll by X date, or else I'm going to have to be forced to move forward with a probation violation. Something along those lines.
So go finish your thought. I'm sorry.
I was just saying, something along those lines would set the parameters here, but here there just aren't any.
Right. The Commonwealth says there is a general obligation to act with the reasonable promptness to comply with the requirements of probation. Do you agree with that?
I would agree with the fact that he has the obligation to comply, and he has to do it. Yes. So I guess, yes, sure, a reasonable amount of time. I don't think 4 weeks necessarily is it. There was obviously some back and forth. It's not that he made no communication at all with the organizer of the batterers program. He did have some communication. It wasn't to the program director's liking, but I think he was still trying to figure out exactly what he was going to do and how to proceed. And I do think it takes some time to contact an attorney and get an opinion as to whether there's a potential to revise and revoke some of those concerns, some of the conditions of probation.
Is it your understanding that there were two grounds for the finding of violation? Because
Yes.
what's on the written findings seems inconsistent with what the judge said at the end of the hearing, where
It was confusing the first time I read it through it as well. I think I based my brief off of the transcript, which had two.
in the transcript,
One
she
had two
seems
and
to
one
be
had
saying
one.
that she's troubled by some ambiguity in the probate court orders, but there's no question that the
Right.
defendant didn't comply with the program. So I would have thought she was relying only on the second ground, but then in the written findings, she checks off both boxes.
That's right. That's right. That's my understanding as well. And because it was in the written finding, I briefed it. There is definitely some ambiguity there based on what she said at the time of the hearing. Yes.
Okay.
Your Honors, I see my time is running Very short. Is there any other questions that I can answer?
I see none. Thank you very much.
Thank you very much.
Good morning. May it please the court, Jennifer Cohen for the Commonwealth. I'd first argue that the defendant was lawfully convicted of the violation of the 2098 order in this case, as there was sufficient evidence for the fact finder to find evidence of all of the elements.
I'm going to ask you just to pull your microphone a little bit closer to you because you're, just so I can hear you a little bit better. Thank you.
Thank you. I disagree with my brother that there was no evidence of a violation here. I think the evidence before the judge was that there was a temporary order from 2013 and that there was a restraining order then issued in 2019. I think just there that the judge was not required to find that that 2013 order was in effect. And frankly, I think that that would be something that would be unreasonable to find. I would also say that the evidence of the child support being mailed does not constitute evidence that the defendant was allowed to contact the victim for whatever reason that he chose. That was his defense to raise. He raised nothing other than the fact that he was able to mail child support payments. And I think as evidenced by the later modifications of the restraining order, the probate court or another court can certainly carve out exceptions to a restraining order, but that clearly was not done in this case, and the defendant was not allowed to send letters in addition to the child support checks. I would say that this case stands on very different footing from Commonwealth and Mendonca, which pertains to the eliciting of evidence regarding the defendant's demeanor during the trial. In that case, the Commonwealth specifically relayed to the court that it would not be proceeding on any theory other than the no contact violation. That did not occur in this case. There was no discussion of what theory the Commonwealth would proceed on prior to the start of trial. At the close of the evidence, the Commonwealth agreed that only the no contact violation instruction should be given. And so I would say that the Commonwealth was able to try to proceed on the no abuse.
Well, to proceed on the no abuse theory, wouldn't you need the prior bad acts?
I am not sure that that would be necessary in every case, but I think the Commonwealth in this case realized that not enough evidence had been provided.
Right, and so then the prior bad acts are excluded.
Yes.
So how is there a good faith basis to be proceeding on a no abuse theory?
I think it would perhaps depend on the testimony of the victim. I think maybe if she'd testified differently to how she perceived the letters, that perhaps it would have been enough for the Commonwealth to proceed on that theory. I don't think it's the strongest.
Realistically, with just the content of the letters, I don't see how the Commonwealth could meet its burden on a no abuse theory. I think the prior bad acts are pretty essential.
I agree in this case that that is how it shook out, Your Honor. I do agree with that. So I would say that even if you find that it was error to admit that testimony, there was still no substantial risk of a miscarriage of justice here because the case against the defendant was quite strong. The Commonwealth did not reference anything relating to the victim's demeanor in her closing, and the judge also instructed that the jury should not use sympathy when they were coming to their verdict decision. And finally, I would just address the violations of probation. I do agree with Your Honor that it was somewhat unclear from the transcript which way the judge was going to go on the violation of the 209A order. But I do think where her final sentence relating to that violation was something to the effect of, however, this is looking at the evidence in the light most favorable to the defendant. I think she's kind of in essence saying she's not required to find that there was any confusion around the orders. And I think that finding is supported by the record where, again, the defendant is relying on a 2013 temporary order to show that he's able to contact her. I don't think that's reasonable. And I think the judge herself said there's nothing in these later modifications around custody that discuss communication or anything like that. Well, that says that the 209A order stands, that the no contact order remains in place. So I think the record supports a finding that the defendant did, on a preponderance of the evidence, violate on both the restraining order and the failure to enroll in the program.
Can I ask about the failure to enroll? This isn't an uncommon situation, right, where there's some kind of requirement of probation and that's mandating a program or treatment or something like that, and the defendant reacts negatively to it, right? Says, oh, hell no, I don't want to do that, right? And so I guess the question is that kind of reaction enough to establish a violation? Because there didn't seem to be a lot of time here. 4 weeks is not a lot of time where there's no time set forth in the 209A order itself. So I'm just trying to, how do we determine that there's a violation that occurred here?
Sure. So, of course, it would be best practice to have a deadline for enrollment. I think this case would be on very different footing if there had been any evidence that after the defendant's call with the batterers program coordinator, he had reached back out to try to schedule an appointment. If his attorney had raised any evidence around, difficulties with scheduling or anything like that. There was absolutely no evidence that this was anything but the defendant deciding, as my brother said, that he did not want to enter the program. It would be very different if during the phone call he'd expressed anger and said, I have to look at my schedule or something. This was a blatant, he just was not going to enter into the program. And there's no evidence that he ever intended to do that. There's no evidence that he filed the revise and revoke that he claimed that he was going to file. I think here it's less about the time frame and it's more about the actions or lack of action that the defendant took.
Thank you.
I'll rest on my brief. Thank you
Yes,
very
you
much.
will. Thank you very much. Thank you both very much. Okay, we're going to proceed and hear the first of the 3 civil cases on our list today, and then we'll take a short morning break, okay? And the first one we have is James Rosencranz versus IANTHUS Capital Holdings, 2023-0878. And counsel can correct my pronunciation of the Capital Holdings when you start your argument. Good morning.
Good morning. Good morning. If it please the court, my name is James Rosencranz, and I am the pro se plaintiff appellant in this case. And I know that you've read the briefs and you've looked at the record. When one reads the briefs, we do know that the agreement is governed by Massachusetts law, meaning that it is governed by the holding of the SJC in Warfield versus BIDMC. We know that there's no testimony of witnesses, so there's no issues of credibility to be decided, and that your review is de novo. Kind of shockingly, actually, I think, the defendants argue that the FAA applies here, even though the agreement itself, the employment agreement, says that it is to be governed by Massachusetts law without regard to choice of law provisions of Massachusetts. So clearly, it's a Massachusetts case, not to be decided by the FAA.
Well, in Warfield, the agreement also expressly said it's governed by Massachusetts law, but the court noted, but, you know, the FAA, if it still comes within the scope of the FAA, then you look at those provisions as well. So I don't know if the choice of law provision is dispositive of whether the FAA applies.
Well, it's dispositive in this way. Well, let me first address the issue that you brought up with regard to Warfield. They said that the FAA would be applicable because of the hospital's status as it being in the healthcare industry and therefore being in interstate commerce by definition.
And that's a different question. I know you say that there's no interstate commerce here, but my question was simply that doesn't Warfield say that the choice of law provision in the agreement doesn't mean that the FAA is not applicable? Right? You can still have the FAA come into play even if the agreement says Massachusetts law applies.
I would say that only if the agreement is either in interstate commerce and I don't believe that Warfield says anything about the actual choice of law provision per se.
Well, it says by its express terms, the agreement is governed by Massachusetts law.
Yes.
And thus the Massachusetts Arbitration Act applies at the same time the agreement comes within the scope of the Federal Arbitration Act.
Right. It comes within the scope
because of the interstate commerce.
Right.
So can you explain why this isn't interstate commerce?
Why this is not in interstate commerce? Well, it's not in interstate commerce because it was a dispensary. And a dispensary, a cannabis dispensary, by definition, cannot engage in interstate commerce. At the time that this agreement was extant, there was no adult use conducted by this dispensary, so that this argument that the defendants have made that people from out of state come in to purchase cannabis was not correct. There was nobody in there who was not a Massachusetts resident. There were no customers. There were patients, customers being adult use people. And so, and the position in
So you're saying that the dispensary could not serve any patients that were from outside of Massachusetts?
That's correct.
And can you point me to that?
I would have to point you to, and I don't have it in front of me, but to the regulations from the Cannabis Control Commission and the rules and regulations that had been promulgated that limited dispensaries to, medical dispensaries to people who were in the state, that were residents of the state. And that included caretakers of patients who had also had a quote-unquote caretaker who could make recommendations and purchase for them. They had also been licensed by the Cannabis Control Commission and had an ID that said that who they were and what they were to that patient. But but all of those people had to be, and I believe that the brief says this.
Yeah.
My brief says that they all had to be, even those people had to be Massachusetts residents, and there was nobody else coming in. And in fact, unless I am mistaken, this particular dispensary, while it has other locations, the ones that the appellant worked at, is, I believe, still medical only. I could be wrong on that, but I don't believe that I am.
Okay.
So just to finish up your question, Justice Shin, I don't think that Warfield actually says or refers to the choice of law provision. I also want to bring up with regard to that in Jewel, for instance, which was decided 2 years later than Warfield, with the same panel, essentially, except that Justice Marshall had retired, Justice Ireland took her place, and Judge Gantz became the chief. But it was still, both of those decisions, Jewel and Warfield, were written by Judge Botsford. And I don't think that there's anybody who would say that within 2 years of a decision that that same makeup of the court, that same author of the opinion is going to abrogate or do away somehow in Jewel with that. In fact, in Jewel, by the contract in Jewel, it said that it was subject to both Massachusetts and the FAA in writing. It was a bit different than Warfield, but they still were going to apply Warfield. But if you look, contrary to what the defendants have stated about Jewel, if you look at Jewel, it says that with respect to Jewel and Simmons, however, this is at 8990 of Jewel, if the arbitration, with respect to Jewel and Simmons, however, if the arbitration provision in Simmons' employment agreement is valid, an issue that remains to be resolved. So the Jewel court, the SJC, didn't make any decision on the actual application of Warfield to the Jewel decision, whereas the defendants argued that they did, and it's clearly not there. Mm-hmm. I think that a lot of the defendants' argument is frivolous, actually, because of they are the ones that drafted the agreement.
Mr. Rosencranz,
Yes, sir.
You argue in your brief that the Mayflowers changed its tactics, arguing that federal law, not Massachusetts law, exclusively controls. So is your position they didn't raise the Federal Arbitration Act below?
Oh, no, they did.
They did?
Mm-hmm. They did.
Did they argue preemption below?
They didn't argue preemption per se. They were still arguing at that point that Jewel, strike that, I'm sorry, that this agreement did not come under Warfield because their argument is that the agreement, the clause, the arbitration clause, is so broad, that it includes discrimination even though it doesn't say that. If you look at all of the other cases, if you look at Jewel, for instance, even though they don't decide it, Jewel contains, it says claims of discrimination. And footnote 7 in Jewel, I believe. Mm-hmm. I will point out that this...
But how does that preclude the interpretation of the clause at stake here?
How does that...
How does it preclude an interpretation that the judge, for example, had of this clause here, that it is, as you pointed out, broad enough to include claims of discrimination?
Because that's not the Warfield standard. The Warfield standard is not broadness. The Warfield standard is clear and unmistakable, unambiguous. Every other case...
But that case also says that you don't have to include every single statutory violation, for example, right? That case also says you don't have to include every single statutory violation. So let's say post-Warfield and drafting this particular employment agreement, the language is different. It says all issues or claims arising from employment, not just from the agreement.
Right. But discrimination claims, because the SJC said these are, and just let me back up for a second. At page 27 of my brief, I said that I never said that you had to cite every statute. I never said that.
But you're saying you do have to cite this one.
No, you don't even have to cite the statute, Your Honor. You just have to say the discrimination, that it applies to discrimination. You don't have to mention, it doesn't have to.
And rising from employment is not sufficient. That's your point, right?
Yes, yes, because that's not the standard. The standard is not broadness. If we're broadness, I mean, I respectfully suggest that nobody could ever find that this clearly and unmistakably and unambiguously, the way that it's written, referred to discrimination. And it's going to bring up discrimination claims in someone's head, the way that it's written. And, you know, what I think, if I may, what the defendants are doing is asking you, this panel, to overturn the SJC. And we know that that's not within the mandate of the appeals court to overturn the SJC.
So assuming we're not going to do that, we're not going to say Concepcion, is that how you pronounce it, overturns Warfield. Your position is you have to have some kind of reference to discrimination claims like they did in Jewell. You don't have to have necessarily 151B, but you have to have some kind of reference to discrimination
Right,
claims.
but you could put in 151B and not use the word discrimination.
But the language here about any controversy or claim arising out of your employment,
Right.
that's just that doesn't satisfy the clear statement rule that's set forth in Warfield.
Right. It can't. Because now you're guessing. What does this cover? I mean, if the SJC wanted it to be broad and that was make that the standard, then I believe the SJC would have said, you can just say anything that arises out of this is covered.
But you raised a number of claims, not just 151B claims, right? So are the other claims then covered by the arbitration agreement? How does that work? If you have one, say you're correct in that the 151B claim isn't covered, but you made other claims in your initial complaint, as I recall, right?
Yeah,
so what happens to those other claims?
Well, those other claims, if you look at the record appendix and the complaint that was filed at the MCAD, those claims were included. There is one claim that wasn't included.
What do you mean by included?
Yeah, what do you mean?
Those were put down as reasons, as supporting. They were split out in the complaint, in my complaint. They were split out, but they were included those claims were all included in the MCAD as part of the discrimination. The only claim that wasn't there was the one against two of the defendants with regard to work conditions on a 100-degree-plus day.
But what happens to those? I think it's Justice Toone's question.
Well, to get to that point, they all are covered by Warfield.
Because you brought them to the MCAD. In the MCAD, you're allowed to bring any claims to but that doesn't mean you're shielded from the impact of the Arbitration Act, right?
But they're on discrimination. They're discrimination claims.
The work environment claim, the claim that the work environment was...
No, Your Honor, that's the one that I'm saying was not brought to the MCAD and does not involve discrimination. But all of the other claims...
I know, but I'm still not hearing the answer to the question as to what happens to that particular claim.
Well...
Does that arise from employment? Does that fall within your employment agreement?
I would say that just for economy, Your Honor, that it should go along with the other cases. I can't make an argument that involves discrimination and that it's covered by Warfield. But the argument with regard to that one claim is that it should go with the others since...
Well, say we don't want to do it for judicial or for economy. We just want to make the right decision as to each claim. Those claims could be subject to arbitration, whereas your 151...
That one claim, Your Honor. No, not the other claims, not the claims about the pants and about those sorts of things, because they were all part of this these discriminatory acts.
You're saying everything is discriminatory except for the incident regarding the air conditioning and the workplace environment that day.
That is correct.
That is still subject to arbitration.
That is correct.
Okay.
That is correct. That is correct. I believe that I am, well, I have one more
You are
minute.
out of time, so I'll see if we have additional questions, and we don't. We answered
Thank
that
you.
question.
Thank you very much.
Good morning, members of the panel, and may it please the court. My name is Kathleen White, and I'm representing the appellees in this matter. I'm here today to ask respectfully that you uphold the decisions of the lower court, including the decision granting our motion to compel arbitration and to dismiss the appellant's complaint at the lower court. The appellant's argument is unavailing for a number of reasons with respect to the enforceability of the arbitration clause. Specifically, I disagree with my brother here that the FAA does not apply. In fact, the FAA does apply. Not only does the FAA apply, it in fact preempts the standard articulated under Warfield that the appellant so heavily relies on in his brief.
No other court has actually held that, right? Held that the FAA preempts the Warfield standard, right? So this would be a case, you're asking us to go out on something of a limb here by holding that.
Yes, I would disagree with the characterization of going out on a limb, but
Feels like that here,
in
right?
fact, in fact, no other court has directly addressed this issue, although it has been discussed in dicta and other cases wherein courts suggest that the correct ruling would be that Warfield is in fact preempted by the FAA. The decision by the United States Supreme Court in Conception involved extremely similar facts to this one in that there was a state-specific public policy that disfavored arbitration of one particular issue, and the FAA determined that to the extent a state implements a more stringent standard for arbitrability, those standards should then be displaced by the FAA. So yes, although it has not been addressed directly, I'm arguing that that is the correct approach to find that in light of Conception, which happened 2 years after Warfield, that the standard regarding the arbitrability of discrimination claims is now displaced by the FAA.
So first, we have to find that this implicates interstate commerce, right?
Yes, that's
So is
correct.
your position that all employment contracts implicate interstate commerce?
I think in 2024, you would be hard-pressed to find one that does not. Certainly, there's a trend of case law acknowledging that the employment relationship in general affects interstate commerce, and I think that's
in the context of Title VII, right?
in the context of Title VII or ADIA.
So they're talking about employers, large employers, well, more than 15 employees, right?
Yes, that's accurate.
Okay. So do we know if this company has more than 15 employees?
This employer does have more than 15
We
employees.
know that from the record?
Yes. Sorry?
Is it in the record? Do we know that?
I am not certain whether or not it's in the record, but I'm happy to clarify that in a letter
No,
following
I
tomorrow's
mean, it
argument.
has to be in the record.
Okay, okay.
But you can't point us to any place in the record.
Not at this moment, no, I cannot.
What about Mr. Rosencranz's argument that this is a dispensary, right? That couldn't serve people from outside the state. Do you agree with that?
That is the first that I've heard of this restriction on selling to non-residents, including patients.
We know it's not true with respect to non-medicinal marijuana, but that's something I didn't think about, sort of, because you probably need some kind of.
Sorry, can you repeat the question?
Well, I guess, do you have any information as to sort of how the impact of the medical marijuana part of this relates to your argument as to interstate commerce?
Well, I think actually the Supreme Court, in a separate case, Gonzalez versus Reich, I believe they addressed that even the homegrown use of marijuana can impact interstate commerce in the sense that it affects the national supply and demand and affects the market with respect to marijuana. So indeed, I feel even if there were only Massachusetts residents consuming the products sold at the dispensary where the appellant worked, even in that case, interstate commerce is impacted. And I do want to clarify one thing, which is The appellant repeatedly states that the appellee was prevented from engaging in interstate commerce, and first of all, that's inaccurate. They're prohibited from the, apologies?
Selling from state to state.
Exactly.
Right.
They are prohibited from that. However, they are certainly not prohibited from, again, they could hire non-residents. They could transport, sell, and buy equipment and supplies for the dispensary that was not a cannabis product. And indeed, the appellee is actually, and this is acknowledged by the appellant, the appellee is a wholly owned subsidiary of a Canadian corporation, IANTHUS, which that relationship in and of itself inevitably implicates interstate commerce within the meaning of the FAA. And my second point is the FAA does not require that a transaction or relationship constitute an engagement in commerce in and of itself. It simply requires that the relationship or the transaction governed have an effect or involves commerce. So I wanted to clarify that as well. And certainly for all of the reasons that we've articulated, we feel that interstate commerce was certainly implicated in this context and with respect to the employment relationship with the appellant.
So let's assume you've met the interstate commerce hurdle. My reading of the Superior Court decision is that it really just applied the Massachusetts Arbitration Act, not the federal law. Do you disagree with that?
Your reading of, I'm sorry, can you repeat the question?
The Superior Court decision that we're reviewing.
So yes, I believe that the lower court did apply the Massachusetts Arbitration Act and
Applied, it sort of assumed Warfield is the applicable precedent.
Yeah, they
here,
assumed
right?
Warfield is still the law of the land, and for clarity, although that wasn't articulated in the lower court, that there was in fact an FAA preemption argument, because we feel that the clause in question here unquestionably satisfies Warfield. So, you know, we had hoped to.
Let's just focus on that before we get to the FAA preemption, which
Okay.
I guess would be an alternative argument to affirm, because the Superior Court didn't rule on that.
Yes, the Superior Court did not rule specifically on the enforceability under the FAA. However,
We'll get to that. Just sort of focusing on the first point. You say that Warfield.
That's accurate.
Warfield would still apply here, and I don't understand that, because Warfield has this kind of clear and unmistakable standard, and in Juul, or however you say it, they said, well, it would cover disputes related to employment, including without limitation claims of discrimination, right? But there's no reference here in your clause, any controversy or claim arising out of this offer letter or your employment. There's no reference to discrimination here. So assuming that Warfield still has some effect, how do you read that and say it meets the clear and unmistakable requirement that Warfield recognized?
Yeah, that's correct, that our clause is different from the clause in Juul in that it did not articulate the specific examples of claims that could arise from employment. In fact, in Juul, there was not an exhaustive list. There was just a list of some of the most common claims arising out of employment, one of which is discrimination.
But your clause doesn't even have that.
No, it doesn't. But that being said, this case is different from Warfield because the clause is unambiguous. There's no way in which one can reasonably interpret it to apply to all claims arising from employment, but not discrimination claims. The broad claims arising out of employment language, in fact, encompasses those claims, and a reasonable person reading that language would be on notice that such claims would be included. And the court in Warfield even alluded to a situation like this being treated distinctly from the requirement that was set forth in Warfield. Specifically, in Warfield, the court stated in its decision where it decided not to enforce the arbitration clause, it emphasized that the clause in that case referred to disputes arising out of or concerning the employment agreement or negotiations leading to the agreement rather than concerning employment generally. that rather than in concerning employment generally is exactly what we have here, and it deserves different treatment than the standard under Warfield, even if Warfield remains good law, which it's our position that it's a moot point because Warfield is now preempted.
Okay, before we get there, though, so your reading of Warfield doesn't require a clear statement as to discrimination claims. You can just have a broadly stated but emphatic statement as to employment claims, and that's sufficient to satisfy Warfield?
Yes, that's correct. And I think my brother here takes issue with the broad scope of an arbitration agreement and seemingly suggests that if an arbitration agreement is broad, then it cannot be clear and unmistakable, but those two things are not mutually exclusive.
What he's saying is, to ask the response to the question is, what does this cover? He says, it covers everything, and he says, that's too broad.
Well, it covers claims arising out of employment, and certainly...
Like all claims, every claim.
Every claim arising out of employment,
Period.
yes. And I do want to address one thing. The appellant has argued that, or changed the argument today a bit, that he alleges you don't have to necessarily refer to 151B, or you don't necessarily have to refer to discrimination claims, but you have to refer to one of them. And he cited to page 27 of his brief in that statement. And in fact, the brief actually states that the standard in Warfield does not require that discrimination claims are explicitly identified in the language. And he acknowledges that's not the standard laid out in Warfield.
Okay.
I mean, it just to go, not to belabor this, but Warfield, the clause in Warfield said, any claim, controversy, or dispute arising out of or in connection with this agreement, and it was an employment agreement.
Yes.
That seems pretty close to your language of any controversy or claim arising out of this offer letter or your employment. I don't quite see much of a difference between those two.
So I disagree because the clause in Warfield, like you stated, it applied to claims and controversies arising from the agreement or its negotiations. Our clause made exceptionally clear that not only does the clause apply to any claims or controversies arising out of the offer letter, it also applies to your employment. And I think that or is very important to acknowledge there, and is exactly, like I said, the language that in Warfield that suggested a situation like this should be treated distinctly.
It is a little ambiguous, I think, that paragraph in Warfield, because later on, the court goes on to say, more to the point, there's nothing in the arbitration clause or elsewhere in the agreement stating that any claims of employment discrimination are subject to arbitration. And that seems to indicate they are saying that you have to say arbitration somewhere. I mean, how do you reconcile those two statements?
I think, again, that's a testament to the specific facts in Warfield. In that case, the arbitration clause could be interpreted to suggest that only contractual claims are subject to arbitration. There's no similar ambiguity here. So in that case, had the contract itself stated discrimination claims somewhere else, that might have resolved the ambiguity. However, the language of our clause, there's no reading of it where one could reasonably interpret it to apply to only contractual disputes. So I don't think that the same standard necessarily applies. What makes an agreement clear and unmistakable under the facts in Warfield is different from what makes an agreement clear and unmistakable under our facts.
And then do you just want to address the preemption?
Yes, of course. So in Conception, like I said, it was the Supreme Court considered the enforceability of an arbitration agreement wherein the lower courts refused to enforce based on California public policy against this kind of arbitration clause. The court then stated the FAA is the ultimate authority on arbitration clauses, and to the extent a state passes a law that would disfavor arbitration or disfavor arbitration of particular claims, that law or judicial rule or public policy should then be displaced and defer to the FAA. And that's exactly what we have here, a state-specific requirement based on Massachusetts public policy.
I think if you put it that high level of generality of state law disfavoring, maybe you have a good argument, but what actually Conception dealt with was a judicial review regarding the unconscionability of class arbitration waivers. And the court said, when state law prohibits outright the arbitration of a particular type of claim, the FAA displaces the conflicting rule. Here, we don't, Warfield doesn't have an assertion, it didn't involve an assertion of unconscionability. It was a clear statement rule for arbitration provisions insofar as they're purported to apply to 151B claims, right? So I think a clear statement rule seems somewhat different from this kind of outright prohibition that the Supreme Court was considering in Conception.
So it is a bit different from Conception in terms of the Massachusetts public policy. However, Conception also suggested that to the extent states have more stringent standards that would disfavor arbitration or thwart the purpose of the FAA, which is to enforce arbitration agreements according to their terms, that those should also be displaced.
You don't need Conception, right? I mean, you rely on Volt as well.
Apologies?
You rely on Volt as well, right?
Yes, we do rely on Volt as well, and that the FAA states not only are all arbitration agreements enforceable, even those that are ambiguous should be, any disputes as to the ambiguity should be resolved in favor of arbitration. So yes, we believe that the agreement is certainly enforceable under Volt, but we also believe that the standard from Warfield is moot now because Conception has clarified that such standards are displaced.
And as you're aware, we can't overturn the SJC, so in order to do that, we would have to rely on the later Supreme Court case, right? Concepcion, because Volt preceded Warfield, is it right?
Warfield was before Conception, 2 years before.
It was after Volt, right? So
Yes.
this SJC already knew what the Supreme Court had said in Volt and yet ruled the way it did in Warfield. So in order for us to say that Warfield's preempted, we'd have to find a later case from the Supreme Court that makes that clear, right?
I think Conception makes it relatively clear in terms of, in Warfield, it had not yet been established that a public policy running against the purposes of the FAA should be displaced. In fact, I think it's referred to in Warfield and in the appellant's brief as an overriding public policy. That was permissible at the time of Warfield. However, the Supreme Court clarified that that is no longer permissible.
Okay.
I realize I'm out of time, so if there are no
Out of
further
time.
questions.
Thank you for both of you for answering all of our questions. We appreciate it. We'll take the case
Thank
under
you, Your Honors.
advisement. We're also going to take our morning recess now.
All rise. School will stand at recess.
right. We're still morning, so still good morning. So the next case is SHU HUA LIN versus, I'm going to need some help, another Ying Lin and another, 2023-0802.
Good morning to the esteemed panel. May it please the court, my name is Christopher Hemsey. I represent the appellants as well as the defendants down below, which was HSIANG Ying Lin and Michael Pang.
Thank you.
This appeal, and I say this with a caveat, but it's somewhat straightforward because there's no factual findings of the lower court that's being asked to be disturbed on appeal. And it is the application of a law surrounding the statute of limitations of predominantly an unjust enrichment claim. This factually, the two parties, plaintiff and defendant, they're sisters. They're two of 7 sisters. And Michael Pang is a spouse of the defendant.
Mm-hmm.
And the facts that are important are in 2005, when the defendant just recently graduated school. She had wanted to find a condo and purchase a condo. She was a little nervous with finances. Her 2 older sisters provided $10,000 for a down payment, and there was a gift letter to that effect that they both signed and provided to the bank for underwriting in order to qualify for a first and a second mortgage. And that was in 2005. And there was also an agreement that the sisters, because the youngest, the defendant, was going to not only buy her first place, also starting in a new job, but also she was taking care of and living with their mother.
I'm sorry to interrupt you for a moment, but I don't think that the clock is on. Can we double check that? That's okay, it happens. And I'm going to say you used about a minute and a half of your time. But so we'll just keep that in mind, but we'll take care of it as time goes on. No problem.
I think that's probably an accurate.
I think it's about right. I've done this long enough. I think I was about right. Please proceed. Thank you.
Sure, thank you. But after closing, which was in 2005, there is a loose agreement that 3 sisters were each going to contribute 1/3 of a first and second mortgage as well as a condo fee. And I say loose because there's nothing in writing to that effect. The defendant had testified that it was to help with her insecurity financial as well as the fact that she was taking care of their mother. And there were certain checks that were paid from 2005 to 2009. And the checks are in the record. They were admitted as evidence at trial. And the trial judge found, and I think the fact that's very important was that the last check that was provided was in 2009. I believe it was in August of 2009. That was the last payment for whatever agreement there was. It was paid in 2009, and the lawsuit was filed in 2019, some 10 years later. In the lawsuit, there was a request in count 3 for an accounting, but the 2 equitable claims that were presented was one for a resulting trust and the other for unjust enrichment. And the resulting trust stemmed from an argument by the plaintiff that her contributions were to equal a 1/3 ownership share in this condominium. That's a subject to the complaint. And we had litigated, counsel and I, and there was a summary judgment motion, and there was obviously a trial. It was a bench trial, several days, about a year ago. And in the summary judgment motion, I only mention it because it was referenced by the trial judge, I had presented the argument about statute of limitations for both the resulting trust claim as well as the unjust enrichment claim. And in the holding, the summary judgment judge found that the operative date for the statute for resulting trust was an email that occurred in June of 2018 between the 2 sisters. And the judge found in that holding that that's the repudiation of the trust, which therefore started the 6-year statute for the resulting trust. There was no specific mention as to the unjust enrichment claim in that holding. The trial judge, also in her findings of fact and written findings and conclusions of the law, cited in a footnote when talking about the statute of limitations of unjust enrichment, cited the summary judgment holding, as well as the case that dealt with the discovery rule and a breach of contract and not unjust enrichment. And that's how the statute of limitations issue as it relates to unjust enrichment was handled by the trial judge. So first of all, the first point that I had argued was that the statute of limitations as it relates for unjust enrichment, The real estate in this case becomes irrelevant the second that the trial judge found for the defendant on the resulting trust claim. So in order to rely on repudiation in order to start a 6-year timing for an unjust enrichment statute was wrong, because I argue that repudiation is only relevant to a resulting trust, which makes sense because the email in question in 2018 was the plaintiff emailed, and I'm paraphrasing here, and said, I own half the condo.
Isn't it true that not until 2018 did Sharon convey to the plaintiff that she didn't owe her anything?
In response to Stephanie's email that said, I own half, Sharon responded, you don't own anything, I own the entire condo.
I own the entire condo, I don't owe you anything, meaning that she wasn't going to pay her any of the money back.
She stated her opinion that she owed no money.
Right, so why isn't that when a claim for unjust enrichment accrues?
Because that specifically found to be a repudiation of trust. It was a declaration against the interest of that allegation. That becomes irrelevant as the trial judge found that there was no resulting trust.
Forget about the trust. What I'm asking is, at what point did the plaintiff become aware that the defendants were not going to reimburse her for any of the money?
When did the plaintiff become aware? Mm-hmm. She had claimed, first of all, that the fraud was a 2012 refinance when husband and wife refinanced the property. That's how
That's not what I'm asking. So the crux of unjust enrichment is the retention of something belonging to you unjustly.
Correct.
When did plaintiff become aware that the defendants were intending to retain her money?
Well, that finding was not ever made, but what the law says, I believe, is that in 2009, if you had a claim that money I gave voluntarily, that was received voluntarily, and was used for any purpose, that's what starts a 6-year window, which is very generous.
Those aren't unjust enrichment cases. Those are mistaken payment cases. So that makes sense to me, because on a mistaken payment claim, the claim accrues when you make the payment, because that's when the mistake is made. And the statute puts a time period of 6 years for you to discover your mistake and sue upon it, right? The crux of unjust enrichment is not the payment of money, it's the retention of the money. So I don't see how you even have a claim that accrues until you know the other side is going to retain the property.
Well, I think that, first of all, I think what's important about the finding of that, their only argument was presented that this payment was for a 1/3 interest, which was clearly not found. And that's very important, because it wasn't like there was an agreement, there wasn't a contract, there wasn't anything other than this theory that 1/3 payment equaled 1/3 ownership. And I think when the judge finds that that was not the case, and finds no less than 7 major misrepresentations made by this plaintiff, that the concept of knowledge, and I think that the concept of this knowledge, these equitable claims, which are different than the discovery rule of, say, a contract claim. I understand they're quasi-contract, but these equitable claims have a different handling. And I think that if the sole story of the plaintiff is disregarded by the trial judge, what's left is just simply this voluntary payment of money. Now,
that goes to the merits of the claim, not the statute of limitations issue, right? I mean, the statute of limitations issue, the argument you're making now really is about the merits of the judge's finding, not the statute of limitations. Just focusing on this, if you could just follow up with Justice Shin's question, sort of, you can't rely on the mistaken payment cases. So why can't we look at the 2018 correspondence as the triggering event?
because there's nothing particularly different about an email from a legal owner of a condo to say, you don't own my condo. And so to use that as, which would be a discovery, I understand why it's applicable to the trust claim, but in terms of unjust enrichment, to tie it to any reason, and in this case it was the real estate, but to respond simply saying you don't own my condo as what was found by the judge, I think that's very important. It's irrelevant, that email, as it pertains to unjust enrichment, because I do believe that unjust enrichment is money hadn't received for credit or money. And I think that there are cases that say for these equitable principles, and there's lumps of them like restitution, or there's different classifications of the same basic principle. And I think that they give a generous amount of 6 years from the time you give a payment that you eventually claim was unjustly withheld. It's defined by when that benefit is conferred, not necessarily when you learn about it, because in this case, if it was just a case on unjust enrichment, that was the sole claim on here, then it would have to be defined by something other than a repudiation of trust, which was that 2018 email. And I think that that's an important distinction here, because when the judge finds that not only the entire premise of the complaint to be misrepresented, but the checks that were given, the plaintiff said was just her share, not her and her older sister's share, that was trying to come to the court and literally double the payments for credit. She said that she was paying cash from 2009 onward, which was also specifically discredited. The plaintiff was found discredited for trying to reclassify a $3,000 check as a repayment of a second mortgage, and it was found not. The plaintiff was found to lie on the entire concept of the second mortgage and the repayment of it. And these factors are very important, because when the judge who finds these facts, which again are not, they're not trying to be disturbed here on appeal, I think that that's what puts into the case-specific application for this unjust enrichment claim. It's not infinite, because otherwise anyone with an unjust enrichment claim could simply plead fraud and simply plead that I own, could literally do exactly what the plaintiff did here, wait for years, sue under only 2 equitable principles, write an email to which my sister will respond, well, you don't own my condo, I own a condo. You haven't paid 5 cents since '09, which was at that point 9 years earlier. And just by claiming fraud, it shouldn't extend this statute, because the finder of fact, I believe, I think rather the concept of the discovery rule is irrelevant, or at least less relevant than a legal claim in these types of equitable claims. And I believe that that's the cornerstone when you apply what's been found to the law. And I believe that at least the cases, and I do appreciate the distinction, Justice Shin, in terms of in terms of the cases, but in these types of mistaken payments, or these any kind of payment cases which defines that unjust enrichment when the benefit was conferred, it's from the receipt of payment regardless of when it's discovered. And I think that makes sense given the amount of findings that were against that which was represented by the plaintiff. There was a lot of facts that were provided in the appellee brief that cites to these allegations of the verified complaint, and it almost ignores the findings that were made by the trial judge. And as an example, there was a recitation that all this cash was given, and it tries to make this defendant, this somehow she's getting a windfall from the generosity of her 2 older sisters, which, by the way, the third sister testified to similar for the defendant, said it was a gift and it was her condo and we didn't want that. And I just think that given the findings on there and in these types of laws, it's not necessarily, I think the law for equitable claims, they look at, you can't ultimately come to the court in bad faith and as to those matters that are before the court, you can't come in bad faith and with misrepresentations. It gets you out of the box, regardless of what the defendant's actions are. It gets you out of the box for equitable claims.
Can you briefly, you have a minute left, can you briefly address your alternative argument as to the increase in the amount of recovery from $34,000 to $50,000?
Yeah, very simply, I think the judge erred in using real estate, appreciated value of real estate, to tie it into appreciated value of money. By finding that there was no resulting trust, the real estate becomes irrelevant. There was no pleading of a contract. It wasn't an investment agreement. It wasn't like I was giving this money for return to here. And so I think to tie appreciated value to any asset, much less appreciated value in real estate, is not, and to do that without justification by law or any kind of formula or measure to do that, and then have that prejudgment interest on that, it's just, I believe that was an error in terms of the application. I understand what the judge was trying to do, I think, given the nature of the parties' relationship, but I do believe that to tie that value to real estate, which I believe becomes irrelevant when the resulting trust claim is lost, that it's not necessarily correlated to.
But you didn't file a motion for new trial or any post-judgment motion asking for a reduction in damages, right? So we don't know what the judge's rationale was.
I just relied on the written holding.
But doesn't that mean that the issue is not preserved? I mean, our cases say that you have to bring this to the attention of the judge first. Otherwise,
I think that, I understand your point, but I believe I was properly before, Your Honors.
But this was a bench trial, correct? This was a
It was.
jury trial, okay.
Yeah, it was. I see my time is up.
Yeah.
I thank you all for your time and
Very much.
attention.
Good morning, Your Honors. John Harkeby for the plaintiff and the appellee. And I apologize if I lose my voice. As my brother said, it's a case between two sisters, and it's unfortunate. But getting to the point of the unjust enrichment and the statute of limitations, I think the judge who heard the summary judgment, I think the trial judge got it right, that the email in June is the time frame for the start of the claim. And although the court didn't find a resulting trust, she did say the intent of the parties at the time of the execution of the deed controls whether a resulting trust is created. So she found against us. I was disappointed in that. I thought the trial judge, who had, the Superior Court judge had gotten to the point at summary judgment to almost get to the point saying that my client did own a share. That was the only issue for trial. She didn't go that far. The trial judge found against us. Very disappointing result. But the court did find, the trial court found, the communications and behavior of the parties do reflect an expectation by all parties that both Amy and Stephanie, Amy is the third sister, and Stephanie would realize some form of repayment for their contributions toward Sharon's ownership of the unit. And that was at page 7. And the trial court credited Stephanie's testimony with $34,088. And that was a lot less than my client testified to. One thing my brother pointed out was Amy's testimony. Actually, she was deposed and she went to Taiwan, but right before the trial. And she did get a credit of her share of the unit in 2016. So she did get a significant value. So the court could have utilized that and said, yeah, she got 1/3. Everyone treated it as that. There was testimony from Michael Pang, the husband, who had sent emails saying, you have 1/3 and we'll give you, this value, reducing payments that my clients owed. And all in all, it's a disappointing result for my client. However, the judge did find that, using her equitable powers, that there was unjust enrichment. And I think the case cited by my brother, the important case for this court is the Suffolk Construction versus Benchmark Mechanical Systems, and that it delineated between certain legal claims for money had or mistaken payments versus unjust enrichment. And as Justice Shin pointed out, both the Superior Court judges used that time frame as to when the statute of limitations should begin. With regard to the measure of damages, the court did find that some $34,000, she credited $34,000 in payments through the checks. She did not find, even though there was testimony from Michelle, the other sister, that she did pay, she continued to pay, she only found a limited amount, and she came to $50,000.
So how do you get from 34 to 50,000 under these facts? 'Cause
Well,
there's no equity interest in the property. The judge is saying you get back the money you get now. You maybe get prejudgment interest on that, but why do you tie it to the appreciation of the property over that? That doesn't make any sense to me.
That was unexplained, and however, as I said in my brief, I think my brother had the opportunity to bring a motion.
Well, getting to the distinction raised by Judge Toone, do you have a case that says that where it's a bench trial as opposed to a jury trial?
I think it's both, the cases that I cited in my brief.
I thought those are jury cases, but.
Yeah. I think we said in a case called Spinoza versus Trust that Justice Shin authored that it doesn't apply in bench trials, but we can, that there's no requirement to go and do a 52B motion.
I've forgotten that I said that, but that sounds right to me now.
Very wise decision.
Well, I know, I've tried that with Judge Vuono in October, and she shot me down, and so I'm going to keep. But you did rule in my favor most of the time.
What's the measure of damages in an unjust enrichment case? Is it the value of the benefit conferred?
Yes, I think so.
Okay.
But I think the judge has an in an equitable situation.
Right, the value of the benefit isn't necessarily limited to the amount of the money that's paid, right?
Right. I mean, because the sister, the defendant, couldn't have bought the condo in the first place. And we disagree as to the whole point, but as to what the purpose was. She got a significant benefit because she was able to buy the unit when she couldn't have bought it in the first place. And so the judge has the ability to do the equitable thing. Even using that formula, she cut it down. I'm very bad at math, but I thought it was, if they used the 62% increase, it would have been $55,000. She only awarded $50,000.
I think you're entitled to prejudgment interest on that amount, which will have some appreciative effect, but it just, the reasoning was tying it to the value of the real property. That doesn't seem to be a connection between that finding and the claim that you won on.
I think that the judge has the ability to do justice. And in this case, I thought she was terribly wrong in her finding, but to coming out and not splitting the baby because we lost a significant amount, I think the court should uphold her finding with regard to that. And, it's an abuse of discretion finding, and I don't think she did abuse her discretion in this case. If the court has any other questions?
No, thank you.
Seeing none, thank you both very much. All right, we're now going to reach our last case on the list today. EMBER Pizza Incorporated versus the Town of Harwich, 2023-0315. Good afternoon.
Good afternoon, Honorable Justices. May it please the Court. My name is Raymond Tomlinson. With me today is Mr. William Kelly. We represent the appellants and petitioners below in the certiorari action to well-respected, long-standing restaurants in no longer sleepy Harwich Port known as EMBER Pizza and the Port Restaurant and Bar. after a bit of a tortured procedural history, this case finds its way to you. But at the end of the day, it really is a very simple test of justice. And in this particular instance, we have a situation where, in the nature of certiorari, the lower court substituted its judgment for that of the legislature and failed to protect against the infringement of constitutional rights of these two restaurants when the Harwich Board failed to uphold its affirmative statutory mandate under General Laws, Chapter 140, Section 183A, to prima facie renew a timely submitted employment.
What does prima facie renewal mean?
Sure. Under the statute, similar to the Liquor Control Act, General Laws, Chapter 138, the legislature put in place a series of steps that the board must follow in order to deny or revoke a renewal entertainment license. So to protect the constitutionally protected right.
And there's language about automatic renewals or presumptive renewals in the liquor license statute, but not in the entertainment license statute, correct?
It is correct that there is language prima facie renewal in both of the statutes. My use of the term presumptive renewal may be a bit presumptive. The prima facie renewal is actually read from the language of Chapter 183A in its totality. In other words, if the board wishes to deny renewal, there is a statutory process it must uphold. It must issue notice to the licensee. It must timely hold a hearing, a public hearing on that. If it fails to do either of those two things, okay, and it's important, if you look at paragraph 5 of Section 183A, it first talks about the board having the only discretion available to it under this legislative grant concerning entertainment licenses is that upon the receipt of a timely renewal application, it may simply issue the renewal license, which it did for every other similarly situated licensee in Harwich Port. That's an important issue, okay? So in effect, you have the board exercising the only discretion it has under Section 183A to issue without a public hearing, without any kind of notice, through a consent agenda, issuing renewal entertainment licenses without condition or restriction to every other licensee in Harwich, including a licensee right next door to the port, which is 12 feet away, shares the same airspace, and has a history of liquor and noise violations. Then you have the next step under paragraph 5 of Section 183A that says that if the board wants to deny a renewal license, it doesn't say revoke, suspend, or modify. It says the language is clear. If the board wishes to deny the license, it must issue notice, it must hold a hearing, and it must issue written findings within 30 days after the 45-day period in which it must issue notice and hold. And so while the statute doesn't specifically say prima facie, okay, the legislative intent is clear. The legislative intent is clear in that the only way that the board can deny renewal is to issue notice and hold a public hearing, and if it fails to do that, it must issue the license. And in this case, the board admittedly did nothing. It did nothing, and it knowingly did nothing while it renewed licenses, entertainment licenses for all other licensees in Harwich Port. The reason it did so was because of bias and prejudice, evidence of which was self-servingly removed from the administrative record. We don't even need to get to a conversation, I don't believe, of whether or not the lower court abused its discretion by refusing to consider extrinsic evidence to complete the record. Because from the outset, there is simply no justification for the board's failure to uphold its statutory duty under Chapter 183A. And then it concocted this plan when suit was filed against the board in the federal court for depriving, for more than 4 months. We're talking restaurants that are open and operating. EMBER is a full-time restaurant. For 4 months into the calendar year in 2021, it could not offer entertainment. It could not turn on the television. Nobody could watch a game. The bylaws in Harwich are specific that if you don't have an entertainment license, you cannot offer any entertainment. That is constitutionally protected free speech and expression. Entertainment also includes dancing. So EMBER is operating, its owners are complaining to the then chairman, Larry Ballantyne, what's going on, where are our licenses, you've issued licenses for everybody else, no response. So then the licensees proceed to federal court. Now, the timeline is interesting because they proceed to federal court, they file an action against the board members individually who are not in privity with themselves as the board. This is their individual action and their liability under 42 U.S.C. 1983 and 1985. After that, the board then files conflicts with the State Ethics Commission, notices their conflicts. They now have a personal financial interest in the outcome of this dispute. And then they, instead of taking action timely when they could have, and interestingly, prior to the board's decision to willfully thwart the statutory scheme, at a public meeting of the board, you have the town manager saying, you know, you can renew the licenses and then take action to revoke, suspend, or modify the license, which would have been prudent and proper under the statutory scheme. You cannot simply ignore the statutory scheme. And that willful thwarting of the statutory scheme is why we are here today, and it's why the lower court erred in granting judgment on the pleadings in favor of the town. That error of law was manifest under General Laws, Chapter 30A.
Well, one of the things that the court below said, like, this is all moot, this license is many years expired, right? So why do we have to rule on the merits of all these issues that you're raising? Because it does seem like all the background facts, this is all during the pandemic, and there's a special order 50 to allow for outdoor
entertainment, yes,
dining and all these special rules that exist because of the pandemic. It makes sense.
Yes.
But those conditions don't exist anymore. So the unique circumstances that arose and your various claims, none of that seems likely to recur in the foreseeable future. So the question is, why did the court err by saying this is moot and I'm not going to address the various merits issues?
Two issues in response. The first is that the board had no authority at the time that it acted under Governor Baker's executive orders. It simply lacked any jurisdiction to take the action that it did. The only authority that the board had to act was under General Laws Chapter 138 concerning the liquor license, okay? Its limited grant of authority under 183A.
183, I'm sorry.
Its limited grant of authority, legislative grant of authority concerning entertainment licenses, okay, that's an ongoing injury. They did not renew the licenses as they were required to do under the statute. They did not issue notice. They did not hold a hearing.
Let's say we agree with you on all of that. Where does that get you?
Mm-hmm. So the mootness argument is important because the deprivation of the constitutionally protected interest in entertainment cannot be mooted. However brief was that injury, and we're not talking brief, we're talking 4 to 6 months.
I mean, you don't get damages, right? So
don't get damages.
What possible relief could the court award for something that happened, years ago?
Because the court has the legislative responsibility to shepherd the municipality's strict compliance with the statute. The strict compliance with the statute is in the public interest. You cannot have a board who willfully thwarts a statutory scheme that the legislature has said must be followed. And that
so you're looking just for a
continues today.
statement that says that there was an error? Is that it?
Effectively, this court should reverse the judgment and say it was a clear error of law that the board willfully thwarted the statutory scheme. Judgment must be reversed. It's as simple as that.
But if there's no controversy any longer, what does it matter?
I don't believe, I take issue with that, Justice, because again, the injury is ongoing. You have the board, after it issued a new and conditional license in violation of the statute, in accordance with a legal standard, Ballerin, that does not apply to entertainment licenses, okay? After this parade of horribles, 6 days of hearings where there was a public shaming and woodshedding of my clients, where there was inability to be able to effectively cross-examine or put in any evidence, and then that evidence doesn't make its way into the record because it was not accepted by the trial court. You now have a situation where year after year after year, the town renews the entertainment license, even though the licensee has applied for a renewal license consistent with what it carried in 2020, an unconditional entertainment license. They have put an acoustic limitation on this licensee that applies only to one other licensee in the same context, and it happens to be EMBER. So EMBER and the board, year after year, without notice or a public hearing, simply automatically renews, under Section 183, the only discretion that it has, right, is to renew unless they want to deny the license. They haven't denied the license because they know that denying the license lands them right back here. So they continue in this gamesmanship of evading judicial review by not upholding the statutory mandate under 183A, and then just year after year renewing an entertainment license that they wrongfully conditioned back in 21. So the renewal license as it existed in 2020 is the renewal license that should have been renewed in each year thereafter because the board failed to follow.
I don't quite understand that lingering effect, because you look at our decision in DHL Associates that says very clear, each license denial affected the party's rights for one calendar year only. Any entitlement to a license that it may have enjoyed in years past cannot translate into a current entitlement to receive such license. You seem to sort of want us to say, well, they were wrong to impose this acoustic limitation, and if they hadn't done that, you'd be able to have, like, what's the opposite of acoustic? Electric entertainment going forward. But I just don't see how that follows. It doesn't follow from the principle that you have to look at this issue for each license as it comes up at the time.
I disagree, Justice, and here's why. If we take the DHL decision, we read it with Black Rose, and we read it with 1001 Plays, the burden was on the board to prove that their actions were legally justified. There's no legally tenable justification for their willful thwarting of the statutory scheme. Had they not willfully thwarted the statutory scheme, there would be no condition on the license that they could then renew year after year. So that is different from the DHL case that you cited in one particular import, and that is that the mootness doctrine does not apply because the irreparable harm was to a constitutionally protected interest. Unlike the other cases where somebody was trying to add entertainment, like live nude dancing, for example, that was not contemplated before. You have a situation where if the court deems the issue moot, it is shielding the premeditated efforts of a biased board and conflicted board to willfully thwart a statutory scheme and act when it had no discretion to act. And this is
Could I ask you maybe a slightly different way? Let's say we were to agree with you, and we order the trial court to issue judgment reversing the board's decision, and you get such a judgment.
Yes.
What are you going to do with the judgment?
The judgment will immediately require the town to issue the entertainment and modify
Why?
the entertainment because
Why? It has to do with the license from 2021. I don't understand what you're going to do with the judgment that says the board should have issued a license in 2021.
Because the licensees have applied for live entertainment each year consistent with their earlier unconditional license that should have been automatically renewed, but for the board's willfully thwarting the statutory
What you're
scheme.
saying is that you would then have a license for 2021.
Correct.
And that you're going to assume then it would always have been renewed because of your interpretation, that you would now currently have a license.
By operation of law, the board has, it has.
That's what your answer is.
Yes.
That's what you're looking for.
Yes, Madam Justice. The board, it's then incumbent upon the board to follow the statutory scheme. If it chooses to deny a renewal license, there's a process to do that. If it chooses to revoke, modify, or suspend the license, which is a different procedure, it has the right to be able to do that. It cannot simply defy what the legislature has said it must do. And if this court does not stand in judgment of that basic elemental test, I see that I'm running out of time, right?
Yeah, I just want to be sure that you've answered Justice Shin's question. Okay.
And sanction the board for its refusal to uphold its statutory mandate, okay? That is against the very public interest that the board would have you believe moots the issue because COVID has ended. Thank you.
All right. Thank you very much.
Thank you.
Okay. For the town of Harwich?
Good afternoon, Your Honors, and may it please the Court, Justin Amos on behalf of the town of Harwich, and with me this afternoon is Attorney John Davis. I'd like to pick up, Justice Shin, just where you were ending with my friend. What the restaurants should have done, unambiguously in this case, is in 2022, in 2023, and in 2024, filed additional cert actions if they wanted to challenge the license that was issued to them in any of those individual years. They cannot bootstrap an advisory opinion from this court that 4 years ago, we could have had an entire student go through law school in the time since those licenses were issued. If we're going to issue the license in 2021, that means 2022, 2023, and 2024 must separately fall. And as Justice Toone, you pointed out, DHL Associates, this court has already rejected my friend's argument that there is any prima facie renewal of the entertainment licenses under Section 183A. There clearly and categorically is not.
So let's say they file a cert action from one of those licenses within the, it hasn't been mooted by the time it gets here. What is the claim?
I think the claim would be in nature and certiorari that the license that was issued in
What is the substance of the claim? So let's say you bring a certiorari to the 2023 license. From what I understand, those licenses were just renewed with the same condition that was imposed in 2021, right?
Although that's not within the administrative record, yes, that's my understanding.
Then what is the substance of the claim?
That the license should have been issued without the restriction.
But why?
As my friend argues, because there was no basis to impose an acoustic-only condition. It would require
Back in 2021, right?
Not back to 2021, Your Honor, because the 2021 license is expired.
That's where it all stems from.
I mean, I guess, but that has no legal import when we're looking at the fact that the legislature created a truncated review process for administrative decisions that don't fall under 30A.
When they apply for a new license every year, a renewal, or whatever you want to call it, let's say they want to get the condition removed, the acoustic only. How do they get that removed?
Well, they can request a hearing before the board if the board is going to just pull them up as a matter of course and renew them in bulk.
But
they
the
can request
hearing would be about what? Because now you only have acoustic only, so how do you prove that you're entitled to get the condition removed?
So, and I think this comes back a little bit to first principles. Under Section 183A, paragraph 2, the board has the authority to impose conditions upon a license to protect the public as well as patrons at the site from an increase in noise, an increase in traffic, safety and welfare of the community. The restaurants could have asked for a hearing, at which point, to answer your question directly, Justice Shin, they could have put forth evidence to the board that there is no more need for this acoustic-only condition because, for example, there have been no complaints about noise violations for that license year. Show that there's been no violations of their liquor
But that license year, there was a condition of acoustic only. So how do they prove that they're now entitled to get that condition removed, other than saying all the neighbors have moved away?
To show that there had been no violations within that calendar year, to show that there had been no issues with the liquor license that year, there had been no complaints from neighbors to the police department about that year. You show that there is no more need for that, and the burden would be on the restaurants to make that showing. You can't bootstrap it back to 2021, admittedly to a moot license. This court held that in DHL Associates. This court also held that in Highland Tap versus City of Boston, both cases in which this court dismissed appeals as moot from challenges to a license where the licenses had expired for that calendar year. You can also look in our brief, there are about 5 cases, mostly rescripts from the SJC, holding the same thing, both with respect to petitions for certiorari and petitions for mandamus. So under this court's precedent, these licenses are moot. Now, whether the court wants to set that aside and reach the questions anyway is a matter of discretion for the court. But as Judge Perino pointed out below, and as Justice Toone, you recognized this afternoon, the facts and circumstances that gave rise to this issue no longer exist. We are no longer in the throes of the worst respiratory pandemic since the Spanish flu in 1920. The reason that there was delay in this case is not, as my brother argues without any basis whatsoever, that there was bias on behalf of the board, but it's because there was a show cause hearing that was held in August of 2020 that had to be continued because the restaurant's attorney claimed they were unable to meaningfully participate in the process. That was continued because the next available date was January of the following year, given the strains on the municipality in the throes of the Delta wave before we even had publicly available vaccines.
So that was the reason for the board not following the 45-day rule.
Exactly. That kicked it to January. We had the decision from the town administrator in February, and we immediately scheduled those hearings to happen in March. And I quibble somewhat with my friend's representation of what happened with the federal lawsuit. 3 days before the board was going to hold the hearings, they filed suit in federal court. Without any basis whatsoever, they spitefully named the board members individually, not in their official capacity. The restaurants created this potential conflict of interest, which would have, but for invoking the rule of necessity, placed the board in the position where none of them could take any action whatsoever with respect to the license. And it should not be lost on this court. If that's what we had done, what my friend is saying we should have done, we'd be here in a very different posture where my friend would have been up here demanding that the board take action and ascribing some evil motive to the fact that we didn't take action because we were made conflicted by his decision to file suit in federal court 3 days before the hearings were supposed to take place. As to the presence of constitutional issues unmooting this case, my friend doesn't cite a single authority that supports that proposition. The only thing cited in his brief is the Lin versus Murrell case, which is, I think, entirely an opposite and actually supports our view. The SJC held on an appeal from the denial of a preliminary injunction to prevent a tax preparer from conducting business during COVID, that the appeal was moot because the COVID orders had been rescinded, and that there was no basis to exercise discretion to reach the question because the situation was unlikely to reoccur, given that we all hope that COVID's not going to come back. That actually inures in our favor to show that it is unlikely that these set of circumstances will arise and escape review. And on the escape review prong, as Justice Perino correctly noted, and as is set forth, I think, somewhat comprehensively, I believe it's in footnote 7 of our brief, the restaurants didn't move with anything even approaching alacrity here. They did not make any attempt to vindicate their rights before they would have been mooted. They filed, sorry, Justice.
Oh, I just, finish your thought.
They filed suit in the wrong county, acknowledging that there was already a case pending in Barnstable. They nominally named the ABCC and the State Ethics Commission, even though there were no claims brought against them. They brought it in Suffolk County. Judge Mulligan, in her decision, which is the consolidated appeal, recognized that this was forum shopping, plain and simple, that what had been filed in Suffolk Superior Court was nearly indistinguishable from what had been filed in federal court. The fact that they did not serve the town with that first complaint. The first notice we got that there was even a case filed in Suffolk was when we got the short order notice to appear and we downloaded all of that from the docket. We found out that there was a preliminary injunction motion. We were then served with the amended petition in the Suffolk case. Judge Mulligan found there was no irreparable harm here, that the case had to be consolidated, which necessitated moving it to Barnstable. It was about a 2-month delay in the case just to get the case moved to Barnstable. We then have the restaurants file a motion to expand the administrative record to include documents that were never before the board. That was denied by Justice Perino, came up to a single justice of this court. I believe it was Justice Singh, denied that petition. The restaurants asked for an additional 45 days to brief, and before briefing was even made in the trial court, the case was moot.
Since we're going through all the procedure, can you tell me what the status of the federal litigation is? Is Judge Casper's decision now on appeal to the First Circuit?
Yes, the briefing was filed last week. There's a technical error with one of the briefs that's being corrected now. There's then the opportunity for the restaurants and the other real estate holdings and individuals named in the federal action to file their reply.
And the action for judicial review as it pertains to the ABCC appeal, where is that?
My understanding, the last time I checked the docket, is that it had been filed in Suffolk Superior Court, that cross motions for judgment on the pleadings have been filed under the standing order, but I don't believe a hearing has been held yet. But There may have been a hearing,
Judge's
certainly
dec-
no decision.
The judge's decision only mentions an appeal to the ABCC by EMBER. Is there another one by the port from the suspension?
I think that might be a technical error, Your Honor. My understanding is the only appeal that was made to the ABC was by the port related to the 3-day suspension of the liquor license. The ABCC had held 2 hearings, took quite a while to issue a decision that affirmed the board's decision. Then there was an action under 30A in the Superior
One
Court.
additional housekeeping question. Are you arguing that the claim with respect to the outdoor permit is moot?
No, when we never made that argument in the trial court. It's
judge
supported
found
by
that,
substantial
right?
evidence. Pardon me?
The judge found that it was moot, but you're not pressing that argument on appeal.
So what Judge Perino recognized is that there was an argument for mootness that was not pressed by either parties in the trial court. He recognized that it likely is moot, but given that neither party raised that issue before him, he proceeded to the merits. Understanding we didn't present that in the trial court, I can't now stand up here and argue that it's moot before this court. I think we've waived that argument, but it is supported by substantial evidence because there is sufficient evidence in the administrative record upon which a reasonable person could believe that the decision was correct. There were 21 witnesses who
And then,
testified.
with respect to res judicata, what do you say about privity of parties?
I don't quite honestly and candidly, Your Honor, I don't understand how my friend can argue there's not privity of parties here. If you look at the federal court action, named defendants, Ember Pizza, the Port Restaurant, and Bar. Yes, there are 2 additional real estate holding companies.
No, I think they're talking about the defendants.
There doesn't have to be privity of party with respect to defendants. Offensive non-mutual collateral estoppel only requires privity as to the party against whom estoppel is asserted. But even separate from that, the town of Harwich as an entity was named in the federal lawsuit, and the town of Harwich as an entity is named in this suit. So I really am baffled by my friend's argument that there's not privity of parties here, even if privity of defendants was necessary.
Defensive non-mutual collateral estoppel, right?
Well, it's offensive because we're the ones imposing it upon the other side rather than defensive to protect us against an invocation of liability. We are arguing the issue itself is precluded because Judge Casper, in a thorough, I believe, 28-page decision, dismissed all of the claims that my friend is bringing up here, the equal protection claim, the selective enforcement claim, that this was a violation of free speech, that it's overly broad, unduly vague, all addressed by Justice Casper in the United States District Court, all of which was raised to Judge Perino in the trial court.
But how does the fact that that decision, Judge Casper's decision, is now on appeal affect the res judicata argument?
In no way, shape, or form, Your Honor. The fact that a final judgment is on appeal does not mean that it undercuts the finality of that judgment. And if Your Honor would like, I don't have it on hand, but I can provide a citation for that.
That's as a matter of federal common law, right?
Correct. Because this is a federal judgment, we apply the federal law of res judicata.
The rule the same in Massachusetts, do you know?
I believe it is, but to be honest, Your Honor, I have not looked into that in particular. Just a few quick points as well to further address this prima facie renewal argument. Justice Toone, as you recognized, the liquor licensing scheme expressly provides in certain circumstances that a renewal application for a liquor license gives you a presumptive right to have that license renewed for the next licensing year. And I believe I heard my friend concede that there is no language in Section 183A that provides for that same type of what he's been calling prima facie renewal or presumptive renewal, however you want to phrase it. And I think that's important because the liquor licensing regime far predated the entertainment licensing regime. The legislature is presumed to legislate against the background of the laws already there. If the legislature wanted there to be a presumptive right to renewal, it would have written that into the statute the same way that it wrote into the liquor license. I don't see my friend this morning making an argument about constructive grant, so I'll rest on my brief with respect to how there could not possibly be a constructive grant here, and I'll touch just briefly on the Oyster Creek argument my friend makes that after the 45 days has elapsed, the board is essentially divested of authority to take any further action with respect to the license, invoking Oyster Creek, in which the SJC held that that was true under the Wetlands Protections Act. But they're 2 different statutory schemes. Under the Wetlands Protections Act, there's a right to appeal to an administrative agency, and that administrative agency can issue a superseding order of conditions that displaces action by the local board. There is no such process within the entertainment licensing regime that would permit an appeal to an executive agency whose order would supersede that of the boards. If there are no other questions on at least the opening brief, as far as the consolidated appeal, we would renew our request that the appeal be dismissed, final judgment is entered, a denial of a motion for preliminary injunction merges with the final judgment, so there's no reason to even reach that appeal. I understand the prior panel just canceled oral argument, consolidated here, but we would request that that appeal be dismissed as moot, or at the very least, that Judge Mulligan be affirmed. There's nothing but economic damages here. The invocation of per se harm in the context of a First Amendment claim only applies if you have made a showing of a substantial likelihood of success on the First Amendment claim, which was not done.
Well, the appeals have been consolidated already by order of the court, right? So.
Yes, Your Honor. So we would ask that that part of the appeal be dismissed as moot separately from the arguments that are presented with respect to the licensing appeal. If there are no other questions, Your Honor, we'll rest on our brief.
No further questions.
Thank you, Your Honors.
There's no rebuttal.
Not a rebuttal, just a clarification as to what's happening in the trial court in Suffolk regarding the 30A appeal of the port. There has been oral argument. It's under advisement. That's all. Thank you.
Thank you, Your Honor.